Tomorrow, Lordship. Obliged, deeply obliged, my lord.
Item numbers 53 to 60. There is a slight development. The Union Ministry has issued a directive to all the PSUs that wherever its own action is not under challenge or its policy is not under challenge, to have their names deleted. So we have had to file IAs. 3 different IAs have been filed. And obviously they have not come in the list. Let these matters come up along with the IAs, my lord, on a different day.
Okay.
If I have spoken to all the parties, my lord, if it is not inconvenient, can it be on 20th? I am traveling in between extensively.
Okay. I'll not say anything. I'll just adjourn it. You get your...
Your lordship may indicate that we have filed IAs. Those IAs may be tagged.
Mr. I. Chaudhary, learned senior counsel appearing for the Indian Oil Corporation, submits that that IAs have been, so that interlocutory applications have been filed in the matter, which has not, however, been listed. So he prays that the matter be taken up on 29/2024, along with the said interlocutory applications. Also, the prayer is not objected to by the learned counsel for the petitioners. So accordingly, registry to list this matters again on 29/2024, along with the interlocutory applications stated to have been filed in the matter. Yes.
Legal lordship. Item number 32, lordship. I've entered that the CD not received, lordship. Any date in the next week, lordship. 32, lord.
You are A. Sharma.
Yes, sir, my lord.
Mr. A. Sharma, learned, heard Mr. A. Sharma, learned counsel for the petitioner, also heard Mr. K.K. Parasa, learned additional PP. Full stop. It is submitted at the bar that the case diary in the present
They did not receive, lordship.
has not been received. Accordingly, registry to list this matter again on when?
Mukalma on Malat 12 Malat.
On 12/9/2024.
Obliged.
Yes, Mr. Chaudhary.
I'm praying for listing of a matter tomorrow, lordship. Obliged.
Maybe same prayer, lordship. Obliged. May I please, your lordship. Lordship, I beg to mention item number 62 of the supplementary list, my lord. The matter may be passed over for the day. I have taken consent of the other party, lordship.
Why?
Lordship, the conducting counsel has some difficulty, my lord. His daughter is not, has some medical emergency.
Mr. Ahmed
And Ahmed.
and Ahmed.
And Ahmed.
He is having problem.
Yes, lord.
A prayer is made on behalf of Ms. N. Ahmed, learned counsel for the petitioner, on the ground of personal inconvenience. Full stop. The prayer is made for adjournment of the matter on the ground of personal inconvenience of the arguing counsel, Mr. N. Ahmed. Full stop. The said prayer is not objected to by the learned counsel for the respondent. Registry to list this matters again after a week on a date to be fixed by it.
Highly obliged.
May I please, your lordship?
Yes.
It's item number 49, my lord.
40?
49, my lord, from hearing column, my lord. We need 1 week time to go through, my lord. All the vulnerable persons are not clear, my lord. It's a long pending appeal.
13 matter.
Yes, my lord. Persons are not clear, my lord.
On the prayer of Mr. Your H. No. Your name is not here.
No, my lord.
On the prayer made on behalf of Mr. B. Mahajan, a prayer made by the learned counsel for the petitioner, who submits that he requires upward a week's time to prepare the matter after perusal of the depositions of the witnesses from the original records. Prayer granted, prayer allowed, registry to list this matter again after a week on a date to fixed by.
My lord. Obliged.
There is a gentleman, yes. Gentleman.
Sir, I'm in person, sir. Registry is not, filing section is not directing the registry to list my case. Because, sir, some administrative reasons are there. I have forwarded the application to the court master, sir.
What is the matter?
Sir, WP criminal, sir, filing number 8035/24. It is cleared by the filing department, but is not being listed.
Why? What is the administrative problem?
Sir, some question of law and fact is involved, sir. They are saying,
No. Why is the matter not being listed?
sir,
Why is the matter not being listed?
sir, they are saying go to the court and ask the formal permission for listing. Some matter is somehow related to state of Arunachal Pradesh, but the cause of action is here in Guwahati, sir. On the same fact, multiple FIRs has been lodged. For second FIR, I am here, filed the writ petition, for which I am here to for listing, sir. Lordship, one more thing, I have come here from UP, sir, so I have to go UP, otherwise, if it will get listed in next week, it will be very hardship for me to come here again for hearing of the case, Lordship. Kindly, Lordship, allow this application for urgent listing and take up.
The cause of action is in Arunachal.
No, sir, this is Guwahati, sir.
What is the issue?
Issue is that they are saying that we cannot take up the matter, we cannot list the matter because this FIR is related to Arunachal Pradesh.
You will have to take a permission from the Chief Justice for that.
Lordship.
You will have to take a permission from the Chief Justice if the FIR is of Arunachal Pradesh.
But sir, cause of
That is a different issue altogether, Mr. If the FIR is of Arunachal,
sir,
a police station in Arunachal, so you will have to have the matter moved before the Itanagar bench. You can approach the Honorable Chief Justice. It's only the Chief Justice who has the power to permit you to file and move the matter here. Otherwise, you will have to go before the Itanagar bench of this court. Okay? You approach if the FIR is of Arunachal, you will have to approach the Honorable Chief Justice by way of an application. And the application has to be routed through the registry. You give it to the registry, they will put it up. Okay? And you give your mobile number and your email ID. They will inform you about the date. You can put a line there also. Lots.
May I tell? If I beg to mention item number 8, I may be allowed to withdraw this petition. Item number 8.
Withdraw.
Why?
Lordship, as per instruction, Lordship, they may.
Mr. AMS Moshuntar, Learned Counsel for the petitioner, submits on instructions that he may be permitted to withdraw the present bail application. Prayer is not objected to by the, what was the issue here?
Lordship, he was in custody, Lordship. Petitioner is in custody, Lordship.
I know that. What was the offense?
Offense 307-324.
Charge-sheeted case, already charge-sheeted,
Ah,
and bail rejected by the tribunal.
trial court.
For trial.
Within stage now.
Submits that so and so prayer is not objected to by Mr. K.K. Parasal, and additionally, accordingly, the bail application stands dismissed on withdrawal.
Obliged.
I beg to mention item number 25 matter. Matter may be adjourned for the day.
20? 25.
Why? 25 CD has come.
Matlab CD not received.
Mr. On the prayer of the Learned Counsel for the parties, registry to list this matter again on
Charge-sheet submitted.
Shashit Summit.
Matlab yes.
Then,
My engaged counsel due to some personal. My engaged counsel due to some personal.
Oh.
Please show.
tomorrow. Kali. Item number 25 as prayed for by the Learned Counsel for the petitioner. List this matter again tomorrow. By slip koi dibo.
I beg to mention item number 31 nation. CD notice inclusion.
CD has been received.
Item
31.
31. 31. Sorry, madam, CD not received. He is an interim.
Interim shall be continued.
At the Learned Counsel for the parties, it is submitted at the bar that the CD case diary has not been received. Also, accordingly, registry to list this matter again on
On 18/9, madam.
18/9/2024, the CDP produced on the said date. Interim order passed earlier to continue till the next date of listing.
Much of
Yes,
For listing of a matter on a tomorrow on a bail application, the matter pertains to accrued.
Today's daily course list, delivery of order item 1.
1, 2, 3, 4, and 5. I'll pass the orders CAV. Please. At the Learned Counsel for the parties at length. case judgment reserved. We'll pass the orders next week. Save it.
Motion BA, item 6.
Registered to list this matter again on 13/9/2024. Similar matter is coming up on 13/9.
13.
7.
Third day, learned counsel for the parties. Your name?
J. Abbas.
J.
Abbas.
Abbas. Also heard Mr. So-and-so. Call for the issue notice. Call for the CD. Registered to list this matter again on
12, my lord.
12/9/20. You will get it.
Today is the 42 days lordship.
Hmm?
42 days today.
Be there for some more time.
Lordship short day maybe.
The allegation is not very.
My lord,
Lordship.
12.
Is it
Oh, brother.
confidential relation, lordship?
12/9.
Yes. How like that?
Hmm.
But he was arrested for 19/8/2024. Allegation is that fellow, it said that in the year of 2000.
Mr. N. Uddin, learned counsel for the petition, also heard Mr. K.K. Prasad, learned counsel for the learned edition PP. Issue notice. Call for the case diary. List, registered to list this matter again on
13/9.
13/9.
Obliged.
A minor girl earlier, when the offense took place.
2021, they are saying.
Item
10. You, Sunny. Top of the list adjournable. No, top of the list adjournable. 53 to 60 adjournable. What?
top of the list, item 10.
We'll have it when I'm sitting on a non-criminal bench. Otherwise, I've heard, where is Mr. Chaudhary?
I'll call him. I'll inform him.
You just call him. We'll pass on this.
Item 11.
Procedural lordship. For the petitioner lordship, today we have filed a wakalat nama. We have not received the copy yet. We have not yet received the copy.
Of what?
Copy.
Of copy of
Means the earlier means it is a transfer case lordship.
I know that. What copy have you not? They have not filed any affidavit. You have not received the copy of the transfer petition itself.
It was earlier on the Arunachal means bench lordship. So that's why on over phone the petitioner engaged us. Actually, we have the brief of the case we have not yet received. Lordship. One
Lordship.
week time may be granted. Lordship.
Lordship, we have also we have to receive the copy, Lordship.
But one thing, we examine one thing. The Miss Sonam respondent number 2
Lordship,
is the informant. But the victims are different.
Lordship,
They have not been made party respondents here.
Lordship,
They have to be made.
Lordship.
Huh? And I don't understand what exactly is the grievance. As prayed for by the learned counsel for the parties, registered to list this matter again on 16/9/2020.
Much obliged.
Check up respondent number 2. Service is not complete. Maybe you will have to, we'll take it up on next day. You get your briefs.
12.
This revision has been prepared against the order filed by.
You are the husband.
I'm the husband.
Your father deposed against you.
Lordship.
Then
I'm only on law point, Lordship.
no law point here.
The quantum has been decided in violation of the.
I don't think so. We'll have, if we, at the most that I can do is, issue a notice. If you want to argue, I can go ahead.
I regularly pay 4,000 that
No.
is by the trial court.
No,
Lordship.
you pay the whole amount, we'll subject to the
I'm-
orders after. she
I'm
comes.
already paying, Lordship. I will continue to pay.
You continue to pay what has been directed,
Lordship,
8,000.
Otherwise, Lordship,
Nothing, that's just a paltry amount and I propose to increase that amount.
but
You want to
I'm-
hear it? I can hear it now. The whole factor is admitted by your father. Deposition of your father.
Lordship, I'm on Lordship that apex court judgment that my assets are not acquired. Lordship.
Your asset, it is already taken, 87,000 plus.
Lordship, no, affidavit on affidavit, Lordship.
Did not be, you did not even adduce evidence. You did not even adduce evidence. Why should the court go wait for that?
It is mandatory to both parties. Lordship.
No, the material has been brought out, your salary or your position was established. You did not dispute that, you did not produce any evidence. Want a notice? I can issue a notice, not more than that.
Lordship, notice and I regularly pay 4,000.
No. 8,000. I'll make a clear observation to that effect.
Now presently he is unemployed. He was working.
Why
in
don't
private company, Lordship.
Ask him to do. There are Supreme Court judgments. If he is able man, he will have to do a work of a labor to feed. That is the law. And here the father is deposing everything. And see the manner in which 1 and 3 had dealt with the person. Heard the legal counsel for the petitioner, also heard Mr.
Sole respondent.
First issue, the present application has been so filed, assailing a judgment, assailing the judgment dated 1/7/2024, passed by the learned Session Judge Udalguri in Criminal Appeal number 8/2024. Also, issue notice, returnable 4 weeks. Petitioner to take steps for service of notice upon the respondent number, the sole respondent by way of registered post with AD. Steps within 3 working days from today. Also, the interim prayer so made by the petitioner in the present proceedings shall be considered upon the sole respondent's entering appearance in the matter. Also, the petitioner shall, in the meantime, comply with the directions passed by the judgment and order dated 1/7/2024 in Criminal Appeal number 8/2024. You continue to pay 8,000, interim will consider when she comes. You should have been satisfied with this 8,000. Now you are exposing yourself to an increase. That's it.
The proceeding in this case is under submission. Lordship will find the FIR at page 19.
Heard Mr. R. Bora, learned counsel for the petitioner, also heard Mr. K.K. Parasa, learned additional PP. Full stop. Issue notice returnable 4 weeks. Mr. Parasa accepts notice on behalf of the respondent number 1. Full stop. Petitioner to take steps for service of notice upon the respondent number 2 by way of registered post with AD. Full stop. Pending. Full stop.
My lord, one thing is that my only cognizance taken, such is not a frame. At the framing of such was
See,
taken.
one thing, here that material was stolen, there is no material. Then
But they can raise the objection at the time of framing of such.
why they are before us? Let us also examine. Also, considering the allegations so leveled against the petitioner in the charge sheet, comma, the material in question not having been established to have been stolen, comma, this court is of the prima facie view that the petitioner has made out a case for interim relief. Accordingly, further proceedings in
PRC number 38 of 2020.
PRC number 38 PRC number
30 of
30 of 2023, pending in the court
Before
of the
JMS.
learned judicial magistrate first class, West Karbi Anglong,
at Hamren.
shall remain stayed.
Okay.
Stayed or suspended? Both same. Stayed, stayed will do.
State.
Stayed. I'm only on that. You satisfy me on that, we'll vacate this one. Register to list this matter again after 4 weeks, huh? On a date to be fixed by.
14.
Yes, Mr. Parasa. Admittedly, seizure made by from different persons, maybe in the same train. Whether it can be amalgamated
Let the
without,
materials are not yet available. Matlab, these are matlab, their materials. Matlab, let the scan copy come. Matlab, then matlab, otherwise, matlab, yes, from different
persons, and there is no allegation that they were all
together.
Yes.
together.
Same.
In that view of the matter, what should this court do? I don't want to stay the proceedings.
Matlab, Sasha.
Tashida.
Different state also.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K. Parasar, learned counsel for the learned additional PP. Issue notice returnable 4 weeks. Also. Mr. Parasar, learned additional PP accepts notice on behalf of the respondent number 1
Who is also not
No, no.
a police officer?
by name.
Yes, because he's the
You
informant.
take, you take.
Okay, no, sir.
Mr. The learned counsel for the petitioner take steps for service of notice upon the respondent number 2 by way of registered post with AD. Also. Registry to requisition the scan copy of the charge sheet.
Special NAR case number 55.
Charge sheet number.
Special case number.
Now,
Charge sheet number.
special, record of the special case
Scan copy of the record of the special case number
43/BGN/24.
43 oblique BVL
BGN.
Huh?
Bongaigaon. BGN. Bongaigaon.
BGN oblique 2024.
Case number 1 was.
Or 55.
Special bracketed NAR case, bracket over, case number 55, bracketed BGN, bracket over, oblique 2024, from the court of the learned special judge, Bongaigaon. Registered to list this matter again after 4 weeks on a date to be fixed by it. We'll see. You have made out a case, let's see. You don't have an interim prayer.
Because of, yes, Lordship. Because of this, Lordship, we are in the detention, Lordship. Still, we are in touch.
Because there is no interim prayer, nothing.
Yes, Lordship.
So we'll have the records
Yeah,
then.
it stays there.
Said that
They
you
will
go.
really affect the petitioner, Lordship. That's
Okay,
why we
fine.
have not made it.
15.
Next resolution.
Hmm.
Here, my lord, respondent number 2, my lord, filed an FIR, my lord, against the petitioner, including of his father. Not wherein, my lord, police, my lord, submitted, my lord, FIR, my lord. You should kindly see case number 46, my lord.
Then a complaint case was raised.
My lord,
And that in that complaint case, now cognizance has been taken.
problem is taken. So, my lord, this is, my lord, totally, my lord, false case, my lord. And here another case is, my lord, pending, my lord, cross case, my lord, against, my lord, present, my lord, respondent number 2, my lord, and her husband, my lord. So that is the main cause, my lord. The subsequent case, my lord. We lost it kindly, my lord. And Supreme, my lord, I am again, this petition is, my lord, for respondent, present petitioner, my lord. There are 5, my lord, accused, my lord. So only for, my lord, I am present petitioner, my lord.
No, if the whole proceeding goes, the whole proceeding goes,
Yes, my lord.
right? Now there are 2 before us.
My lord.
Another 3 is there. Charge sheet, we'll have to call for what? Everything is here only. What is to be called for? Nothing. We only have to issue a notice. Huh?
Complaint case, we are also, at this notice.
Notice will go. serve upon Hazira Khatun, come back, we will hear the matter.
My lord, what will my lord, present petitioner, my lord, they are my lord, resident of my lord, Dorong district, my lord. They are not even resident of my lord, Kolkata
I
district.
got it. But
Lord.
according to me, I also am satisfied that the second proceeding, the complaint case, once an FIR is filed, there was no Naraji petition in that. He has filed this complaint petition.
Right.
So let us consider the issue. You take steps for service of notice upon respond number 2.
Right.
Come back. I'll provide that the interim order will be considered on the next day.
Till then, my lord, then my lord, maybe consider, my lord.
Nothing is going to happen in a month's time.
My lord,
1 date maximum. Heard Mr. J. Islam, Learned Counsel for the petitioner, also heard Mr.
regarding
K.
this, my lord, on similar cases also, my lord, and regarding that, my lord, I beg to submit this order of this honorable court, my lord. Within my lord, stay was there, my lord. So, my lord. Similar case, my lord. FIR was submitted and subsequently, my lord, proceeding was initiated, my lord, that is, my lord, state, my lord. This is, my lord, relating to Morigao district, Nagaon district. Exactly similar case, my lord.
But here say only 2 is before us.
My lord.
Only 2 is before us. The other accused are not before us. So why should I partly do it? I'll do it fully. If the 5 was before me, it would have been a different question altogether. They seem to have no grievance.
Respond number 2, my lord, he is, my lord, a school teacher, my lord. So, my lord, this matter may also be considered, my lord. So, my lord, till my lord, returnable date, my lord. No. So far, my lord.
We'll not segregate that proceeding. Take steps, come back, we will completely consider the matter. If the 5 was before me, I would have considered your prayer.
Only, my lord, limited prayer, my lord, till my lord, returnable date, my lord. So far, my lord, present petition
Same
is concerned,
thing.
my lord. Proceeding may be.
Yes, Mr. Porosar.
My lord. And thereafter, my lord, after hearing the parties, my lord.
Only there are 5. More than how many respondents are there in the original case, in the criminal complaint case now? Complaint case, how many are there? 5.
Complaint against the 5. Total 7%, my lord.
7 persons.
7, my lord.
Only 2 is before me. Heard Mr. J. Islam, Learned Counsel for the petitioner. Also heard Mr. A. Mr. Mr. Parasar, Learned additional PP. Issue notice, returnable 4 weeks. Also. Mr. Parasar accepts notice on behalf of the respondent number 1. Also, petitioner to take steps for service of notice upon the respondent number 2 by way of registered post with AD steps within 3 days. Also, interim prayer would be considered on the returnable date upon appearance of the respondent number 2. We'll see on that day.
Right.
16.
Well, this is under 528 for Quashing appeal. Collaborate, yes, my lord. It is 51 2024. Collaborate is 16 of 2024 under section 498A. My lord, this is a ground, my lord. Here the wife has instituted the case. This is not the first case he has instituted. Earlier occasion, the first initially after the two months of the marriage, that was instituted in.
First, there was a 498 case. Therein you were 498.
Yeah.
Therein you were acquitted. The husband was acquitted, right?
My lord.
Husband was not found guilty.
Yes, in that first case not found guilty.
Now they
they
have
have-
instituted a fresh proceedings.
But she may not never stay with the parents of the husband, because husband is due to her his work style. He has to stay in Guwahati because he's driver of the night super bus. So all the time in the all flimsy grounds, he involved quarrel with the parents, he refused to take the care of the old parents. And ultimately, she for last 11 years, staying with the parents of her. And now what he did, just before filing, after filing of this case, he filed one BB case also in Nagaon. That is also pending. And that is the same ground, again she filed this 498A. So my prayer is, my lord, this, at this stage, notice may go and field and my lord, this proceeding of further proceeding in this statement. Because the grounds I have taken, this is a Bhajanlal case, category 1 and 7 is very much attracted in this case. Because whatever allegation is there in the affair, it is nowhere it is mentioned, it is a 498 is
Heard
actually.
Mr. P. Mount, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned counsel, learned additional PP. The present application has been so instituted under section 528 of the Bharatiya Nagarik Suraksha Samiti 2023, praying for quashing of the charge sheet, for quashing of the FIR in Koliabor PS case number 16/2024, along with a challenge to the order dated 18/5/2024, by which the learned JMFC Koliabor had taken cognizance of the case in PRC number 157 of 2024 under section 498 bracketed A of the /34 IPC. Also, it is contended, issue notice, returnable 4 weeks. Mr. Parasar accepts notice on behalf of the respondent number 1. Also, petitioner to take steps for service of notice upon the respondent number 2 by way of registered post with heading. Also, on consideration of the materials brought on record and also appreciating the fact that the respondent number 2 had earlier lodged a similar allegation against the petitioner and his family, which on being charge sheeted was considered by the court of the learned judicial magistrate first class Tinchika in GR case number 549/2014 and wide judgment and order dated 25/2/2015. The petitioner herein was acquitted of the offense. Petitioner and his family members were acquitted of the offense so alleged against them therein. Full stop. It is seen that subsequently, the FIR dated 4/2/2024 leading to FIR dated 4/2/2024 was lodged by the respondent number 2 herein, leading to registration of Koliabor PS case number 16/2021 under section 498 bracketed A/34. Also, the respondent number 2 has also instituted a DV case number 102/2023 before the court of the learned SDJM Koliabor, which is stated to be pending. Where is that impugned order taking
That is,
cognizance?
my lord, on, passed on 1/7/2024.
Page.
That is probably, my lord, not annexed, my lord.
That's what I don't find it.
It is not annexed, my lord.
Also,
I mentioned, my lord.
in view of the above position,
It's a first class.
this court is of the prima facie view that the petitioner has made out a case for interference in the matter, for an interim direction in the matter. Accordingly, it is directed that further proceedings in PRC case number 157/2024 presently pending disposal before the learned JMFC Judicial Magistrate First Class Koliabor shall remain stayed.
Master.
Registered to list this matter again after 4 weeks on a date to be fixed by.
17.
Yeah, please, Lordship. Lordship, kindly please come at 2 PM, my lord. Senior will appear in this matter.
Registered to list this matters again on 13/9/2024. There is a similar matter coming up on 13/9.
My lord, at 2 PM.
13/9, your similar matter is coming up. Same FIR.
18.
And 20 out of 7. Item 18 and 20, দুটাই different.
Item 18 is the accountant and item 20.
Yes, Mr. Sharma, and protect him, you get your CD.
Lordship, otherwise
17
allegations
actions
are there.
came out.
Allegation is there, but how, allegation is of which year? What happened to your audits in the meantime?
Lordship, the cause has been shown. Cause has been shown in the
Nothing is
forwarding
there.
letter, Lordship, page 16.
Due to self, some preoccupation of self in various or could not submit in time. Proceed against him. Departmentally. Get your thing. We have seen it.
Lordship, just one thing, Lordship, now they are trying to shift the blame to one another. It is,
That we are only, what is the need of a custodial interrogation? Everything on documents.
yes, that is the.
Everything is on documentary evidence. Why do you require custodial? We'll ask him to appear before the police. Mr. H.R. Chaudhary, Learned Counsel for the petitioner, senior counsel, or assisted by Mr.
M.A. Chaudhary.
M.A. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. Sharma, Learned Counsel, Learned Additional PP, appearing for the state respondents. The present bail application has been so filed, praying for grant of pre-arrest bail in connection with Nihilobayeva. Sona IPS case number 82/2024, registered under section 409/34 of the Indian Penal Code. So I peruse the FIR and the other materials brought on record. Also, on a perusal of the materials brought on record, it is revealed that the matter that the allegation leveled against the petitioner pertains to misappropriation of MREGA funds. Also, the allegations so level are based on documentary evidences. Accordingly, it is the considered view of this court that at this stage, the custodial interrogation of the petitioner may not be called for. Also, accordingly, Uport issue notice a call for the CD in the event of arrest of the petitioner in connection with so and so 30,000 like surety appear before the year or list this matter again on when 29/2024 for production of case diary. So same order in item number 20.
Item 20.
20. Both are from the same FIR, Mr. Chaudhary.
My lord,
18 and 20, same FIR.
18 and 20.
18 and 20.
It's same FIR.
Same FIR.
Same FIR.
19 is different.
Hmm.
19 also, my lord, he is a retired in charge secretary Panchayat. And president, your lordship knows the president husband is involved, he is already been arrested. And
Jubar
all
Ali,
the money has been transferred to the president
to
husband.
the
who have given-
petitioner's husbands. You are still continuing in your service?
No, I'm already retired now.
You have retired.
No access to the department. Nothing will happen now.
Heard Mr. H.R. Chaudhary, senior counsel,
Islam.
assisted by Mr.
Jai Islam.
J. Islam, learned counsel, appearing for the petitioner. Also heard Mr. Bishan, learned additional PP, appearing for the state respondents. The present interlocutory application is instituted, praying for pre-arrest bail in connection with Patasar Kusi PS case number 172/2024 under section 420/406/409/201/34 IPC. Also, the allegation against the petitioner who was holding the charge of the post of secretary 104 number Nis Bhawanipur Gaon Panchayat is with regard to misappropriation of the funds. Also, the material brought on record reveals that the said funds were so the said funds were so misappropriated from the account maintained in connection with the said Gaon Panchayat by the husband of the Gaon Panchayat president Also, the petitioner is content, senior counsel for the petitioner has contended that the petitioner has since retired from his services. Also, accordingly, in view of the above position and also noticing that the issue involved here, also noticing that the main accused, Mr. Jubair Ali, that is the husband of the president of the said government, has already been placed under arrest. This court is of the view that the petitioner herein is entitled to be enlarged on pre-arrest bail accordingly. In the event of arrest of the petitioner herein, in connection with Agor case 2, he shall be released on bail bond of ₹30,000 with like surety. Appear before the IO 7 days. Baki eketa condition. List this matter again after 4 weeks for production of case diary.
23rd.
23rd, list again on 23/9 for production of case diary. Report case diary to call query.
Course list, motion item 61.
Yes.
Quashing of NI, which is pending. So, prime content, initially this complaint was dismissed.
What is the error in the appellate order?
Appellate court, my lord, that agreement which was relied upon by the revisionist, my lord, that is the complainant, my lord. It is not a part of the.
No, it is there. It is there.
No,
It
is
is
not
there.
part of the evidence, my lord.
It is there. It was noticed.
No, my lord, kindly come to page number 16, the evidence. Pre-summoning evidence which have been filed, my lord. Report taken
You
for-
come to page 31. That is the order by the.
Page 51. So, my lord, this petition was filed after dismissal of the complaint, my lord, for revocation, my lord. So it cannot be entertained by the trial court, my lord, because the trial court cannot.
Fundus officio. It said we are fundus officio.
My lord.
It said we cannot entertain it. Then the appellate order came.
Yes, my lord.
Where is that appellate order? Page 43.
Yes, my lord.
Huh.
43, my lord.
Hmm.
The operative part, my lord, page number 45.
Hmm.
It was returned for insufficient fund, my lord.
I'm sorry, I can't accept you.
Yes, my lord. Apart from that, my lord, if you, your lordship, see the, my lord, evidence on affidavit, my lord, page number 17, para 6, my lord.
Additional?
Page number 17, my lord.
Page number 7.
The evidence, para 6, my lord. The check got dishonored for the reason that no such account. So if no such account is there, my lord.
Then you are entitled to fraud 420 again now.
Yes, my lord. But NI will not attract my.
No,
lord.
no, no.
For my lord,
You will have to.
I'm relying on.
You have given him this check. You have issued this check, right?
Yes, my lord. It was a security check, my lord. But in
Those things you go and satisfy the court, trial court, not here.
No, my lord, kindly, I'm relying on only one judgment. Because the bank has been merged. This United Bank of India is no more in existence. It has been merged with the Punjab National Bank, my lord. And it has been held that, my lord, after merging of bank, my lord, the check become invalid. And it will not attract.
When was the merger?
My lord,
Merger took place when?
my lord, I'm sorry. The notification issued by the bank.
But these are not your grounds.
Yes, my lord. I'm sorry, my lord.
These are not your grounds.
So, my lord, kindly let me amend my petition.
On the prayer of the learned counsel for the petitioner, raised it to list this matter again after 3 weeks.
Right.
The petition, 3 weeks.
Admission item 21.
Passport, 10 lakhs.
Passport already released.
Passport release.
Yes.
What is more left?
Photo by the police.
Yes.
May I please, Your Lordship?
Only the money is there.
Money.
Only regarding.
Let it be there. It doesn't make any difference to.
Bond, you have to.
My lord, in
It
this
doesn't
case,
make any difference.
in this case,
10 lakhs.
10 lakhs are one petty businessman.
A petty businessman,
10 lakhs.
petty businessman.
Well, in this case, I have received the case diary, voluminous
So
case diary.
Tata and Birla would be what then? If he is petty, then what?
I will execute the bond, Your Lordship. What to
Yes,
do with
what?
the case by the police court?
What?
Well, in this case, I have received the case diary. Well,
That you received on the last day.
The
And you
last-
said that it was voluminous, I want to go through it.
No, my lord, that is regarding the, because this petition is filed, my lord, for releasing the amount of money which
Ah.
which was seized by the police, 10
Ah.
lakh 36.
He says that this is covered by his income tax returns, supported by his income tax
But
returns.
from the, my lord, some of the.
And this was not so collected from the place wherein the betting was going on. This was seized from his house. Right?
That's the my case. That's the my.
From his house.
So, my lord, regarding that, my lord, although my lord CD I have received, my lord, I need a specific report from the IO. Huh?
Why? What prevented you? That was given to you on 21/8. Time was given to you on
Pending
21/8.
for last 2 months. Lord.
Other,
July.
otherwise,
21/8, we had given you that time to Mr. Paraso.
yes.
Mr.
Regarding-
Parasar was there.
My lord, I
And
am
the
I'm not
and
taking
say-
time for going through the case diary, my lord. I have gone through the case diary.
At 2 months.
But my lord,
What prevented you from getting that report?
yes.
Or you want the order of the court for that report? IO is not
But my lord, what are the materials available?
listening to you.
But from the materials available in the case diary, those amounts were, my lord, seized from the residence of Vikas Beria, the present petitioner. And now, my lord, from the
And
materials.
you suspect that this is
a
involved in
habitual-
that betting,
Yes,
right? But this was not seized from the place wherein the betting was taking place.
yes. Thereafter, my lord, initially during regarding that, my lord, police initially arrested one person, mainly my lord, Suprit Biswas, alias Hani Singh. Thereafter, on the basis of his statement, many other persons, police initially, my lord, received source information on the basis of source
I
information.
am not on that. I am only on the question, whoever you have arrested, you have arrested.
Yes.
But the question is whether this 10 lakhs can be released to him or not.
Yes.
That is the only short question involved.
Now-
You make
Now,
your
from the
submissions.
investigation from the materials available in the case diary and not
And my
in the
income
IO,
tax return seized by
those
them.
monies
And the income
collected.
tax disclosed by cash in and my.
That is cash in hand is, what is the cash in hand
Cash
amount?
in 19 lakhs.
19 lakhs. Further 9 lakhs is there. You'll have to, you missed out 9 lakhs.
They are yet to recover.
9 lakhs. You missed out 9 lakhs.
One, my lord, my prayer before.
Now
the
it will be little bit less after the case has been filed.
I will get a specific report from the IO, my lord, regarding all the.
We'll have it on Wednesday. No further. Mr. Doctor, you are on.
Tomorrow, nothing. IO will say they will investigate the matter, investigation pending. Tomorrow, my,
When are you coming back next?
tomorrow, my lord. Because we have filed this on 3rd of July, my lord, and they have
Give
continuously.
him
they have
one
taken
more
time.
day. I'll make it specific. On the next date, we will pass orders. Monday. When are you coming back?
23rd, your lord.
23rd. Okay. Mr.
The lordship may fixed on Thursday, well,
You'll come.
no, Thursday, no. On Monday, lordship.
9.
I'll be on the virtual.
Virtual. Oh, no problem. On the prayer made by the Learned Counsel, Learned Additional PP, I heard Mr. B. Doctor, Learned Senior Counsel. Also heard Mr. So-and-so additional PP appearing for the state respondent. The additional PP submits that he be given a day's time to receive a report from the investigating officer with regard to the seizure made of the amount, the seizure of the amount from the house of the seizure of money from the house of the petitioner. Also, Mr. B. Doctor vehemently opposes the said prayer. However, considering the prayer so made, the learned PP, additional PP is granted a day's time. Raised it to list this matter again on 9/9/2024.
Grateful, Lord.
The petitioner is behind the bars for 47 days, Lordship. in connection with Chanmari police station case.
Yes, what is your submission? He is behind the bus, we know that. What is your submission?
CD was also,
Are you involved in the matter?
Lordship, and that the Lordship one incident was happened, Lordship.
Are you involved? Or the other one is involved? Who is involved?
Actually, the co-accused is already granted bail, Lordship, and in his bail order, Lordship, my name
It is right that you are the man. Will not continue. You be there for some more days. Yes, what is the material?
Yes, my lord, case diary received. my
Has
lord,
the
along-
victim statement be recorded?
Victim statement, my lord, available in the case diary.
What is it?
Victim name the present persons, my lord. Injured, my lord.
Digonto Das, name?
Yes, yes.
Mr. Yes.
Digonto Das and Krishna Bora come and had beaten me very badly, my lord. And one eyewitnesses also, my lord,
injury.
stated the name.
Lordship, is the injury report is coming up?
We are not concerned with the injury report. He
Well,
is seriously ill. He was in the ventilator also. Right?
Yes, my lord.
Lordship, then kindly may fix some other day, Lordship.
Why? Don't want me to dismiss it?
Some other
Huh?
day, Lordship.
Why? Better you stay there for some more time.
Yes, Lordship, some other day, kindly, Lordship. Kindly have some.
The learned edition PP submits that the case diary has been received and materials, incriminating materials against the present petitioner is available on record. It is further submitted that the victim has made his statement and therein has implicated the present petitioner. Full stop. However, the learned counsel for the petitioner submits that he be given the matter be adjourned today and be taken up on any other date to facilitate him to make his submissions in the matter. Prayer accepted. Raised it to list those matters again. How many days you are there behind?
2 days, 48 days. Lordship.
48 days. I think one day pass.
On 13th,
On 16/9.
I'll establish.
23.
On that day, we'll allow him to do
Yes.
60 days.
Ada 20 password meta for pending. Fix the meta and do.
Why?
Council for a petitioner is going to appear interview board of public prosecutor.
Oh,
The time is
who is gone?
R. Gorua.
Oh, R. Burwa. But have you got the CD?
Yes, my lord.
What is that?
PD, my lord, PM report I have received, but PM report is not conclusive, my lord, as per the opinion of the PM report, my lord,
Injuries were there.
that is kept pending till receipt of chemical examiner's report from DFS Kahili, my lord.
But very serious if that. He is coming today, 2 p.m. 2 p.m.
Same period, item 41 also.
23
41.
and 41, 2 p.m. day.
Obviously.
2 p.m. to day.
Bail hearing, item 24.
How is this man involved? Huh?
Yes, my lord, initially, my lord, police arrested one Miraj Ali. Thereafter, my lord, on the basis of his statement, the name of he revealed the name of the other 2 persons, my lord, and one is the present petitioner. And police also, my lord, charged the residence of the present petitioner and recovered an amount of rupees 2,13,000 from his house, my lord.
What is that amount? What is the
That amount
suspicion?
now police suspect that, my lord, because those monies were my lord, delivered from the delivery boy, my lord. They, my lord, one Vikas snatched all those delivery items, and thereafter, my lord, fled away from the place. Thereafter, on the basis of the, my lord, report of the, my lord, that all by investigating all the address, all details from the, my lord, that, my lord, delivery agent, police collected some of the clues and thereafter arrested one Miraj Ali from Mongoldoy. And thereafter he stated
Because
that,
the guy is not arrested,
he was arrested, my lord.
released,
Because Deka, my lord, maybe, my lord, his name is, my lord, used by some other
alias.
persons, my lord.
And Miraz Ali has been released on bail.
Yes, my lord.
Huh?
Yes.
Bail order is there on record. Bail by this court.
No, bail order is not available in the case diary, my lord.
Yes, already in,
Where, from this court,
yes,
where is that order?
the order is not there.
Get that order. We'll see. Get that order. We'll see.
Only in the affair, my lord, there is my name.
There is material. It's a nexus.
But
He says there is
the
a
amount-
gang.
The amount was recovered, my lord, already in my petition filed and hand over to the father of the accused. my lord.
Fine. Just get that Miraz Ali's order. 2 p.m.
Give your-
You type the FIR number, you will get the, in the, Kizok, you type the FIR number, you'll get the order. Get me that.
Give your-
26.
Otherwise, there is, I don't think so anything further is required.
Anticipatory bail, my lord.
Anticipatory, what will he do? You have got him. We'll ask him to appear before the,
Yes.
you get that order.
Where do you want to find?
Item number?
This lady, 376 against her, my lord. Her father has committed the offense. And she is also named in the affair.
But the father's case is coming upon. Father's case is pending.
Father was arrested.
Arrested, it's pending.
But
There is a
this-
bail. It is contended that in pursuance to the order dated 18/7/2024 passed by this court in the present proceedings, the petitioner had approached the investigating officer and had her statement recorded. Also, it is submitted that the petitioner has not misused the liberty so granted to her by this court in the form of the interim pre-arrest bail. Also, the case diary has been perused. However, it is not clear as to the nature of injury suffered by the victim on account of the purported assault made by the petitioner herein. Also, in view of the above position and also considering the fact that the main accused has already been arrested, this court is of the considered view that the petitioner, the interim bail as granted, interim pre-arrest bail as granted to the petitioner is to be made absolute accordingly. The interim pre-arrest bail as granted to the petitioner while the order dated 18/7/2024 by this court in the present proceedings is made absolute subject to the following conditions. The petitioner shall cooperate in the With the above observations and direction, the bail application stands disposed of.
My lord, one unusual favor, item 39 may be taken at 2, my lord. I mean, not
30?
that matter. 39 of it. Just I wanted by the court, my lord. Court
No problem.
12, my. At 2, my.
39 to 2 p.m. appointed.
Obliged.
Item 27.
Dear Lordship, before the petitioner starts, Lordship, I will be allowed to update the case day, Lordship, because
Mr. B. Sharma submits that he be permitted to place, submits that the case diary received by him is not up to date and accordingly prays that the matter be taken upon
23rd,
23/9/2024 for production of a updated case diary. Also, registered to list this matter again on 23/9/2024. Interim order passed earlier to continue till the next day.
28.
20th.
My lord, yes.
482 मतलब yes मतलब their मतलब materials as per मतलब they have not returned the whole rice and though in the affair मतलब
How can that
loss is
be,
around
how
50
can
lakhs.
that will make him eligible, subject him to some
But,
proceedings, what criminal?
But regarding the son, my lord, not much. मतलब he sometime he in the मतलब good मतलब but
Yes, sir.
I'll explain what my learned friend has. It's not like this. I am a miller. As per the agreement, Lordship will kindly see the agreement first, Miller. That is, that misappropriation cannot happen, Miller. My lord, kindly see what is the section which has been added, Miller. It's a breach of trust, Miller. There has to be an entrustment first, Miller. Then
Yes,
I
sir.
have to do. My lord, kindly see This is an agreement with the government of Assam. As a miller, what I have to do, it is absolutely on the basis of, my lord, it's an internet, my lord, I have to, first, I have to give the rice first to the FCI. Then only they will give the petty. How will give it? Your lordship may kindly see clause C of the agreement, my lord. Page 16, my lord. There's an agreement which has been entered with the government of Assam being the miller, my lord. We are a miller only. Kindly see the C. C, then there's a G also clause. The miller, my lord, miller is myself, my lord, the petitioner. Shall deliver advance, my lord, kindly see. Deliver advance CMR to the designated FCI from their own sources, from my sources, my lord, for which equivalent quantity of paddy will be supplied to them by the concerned PPC manager. In case non-availability of the required paddy with the miller in advance, CMR, the miller is to deposit the cost of equivalent FAQ paddy in additional security, my lord. My lord, what is this? First, I have to give the rice.
CMR means?
CMR means customized rice miller.
Okay.
Custom mill rice miller. CMR is custom mill size and FSD miller, food storage depots miller. Now kindly see how we have to give. I have already miller given to this. It is everything is online. Online is this. I have to give first to the FCI. Then FCI, what kindly see what they do. Lordship will kindly see page 19, kindly see J2, my lord. Delivery of rice. How you have to give? J2, the miller shall not allow to leave paddy from PPC unless they submit the acceptance loss and weight checkup memo in respect of CMR they have delivered to the FCI on previous occasion, my lord. The paddy will be given to me when, my lord, I will give so and so. Now, how it has been given? Now, suppose I have given these things, my lord. FS, this, suppose this is, my lord. I have, so the 3 series, your lordship, from page 25 onwards, kindly see. There's an exception notice, my lord. Raw rice, common, my lord. This is FCI, Food Corporation of India, my lord.
Okay, you are on interim bail.
Interim bill, I have done, I cooperated, my lord.
Yes, appears statement recorded, but only thing is that though in the FR there is the appropriate loss of 50 lakhs around government exchequer. Now IO after investigation has stated that around 40 lakhs.
That would be,
lost.
that is in pursuance to an agreement. If that be so, institute a civil suit against him for recovery.
Recover.
By doing a criminal case, how are you going to recover the money? Mr. P. Bora, Learned Counsel for the petition, assisted by Ms. P. Bora, Learned Senior Counsel, assisted by Ms. K. Bhattchaji, Learned Counsel appearing for the petitioner. Also have Mr. K. K. Parasar, Learned Additional PP for the state respondents. So, the present application has been so filed for grant of pre-arrest bail in connection with Moranhat PS case number 28/2024 under section 61 bracketed 2/316 bracketed 3/316 bracketed 5 of the BNS 2023. Also, this court, wide order dated 5/8/2024, had, on consideration of the matter, proceeded to grant interim pre-arrest bail to the petitioners herein, subject to the condition as mentioned in the said order. Also, it is contended. Also, the case diary has been received and it is seen that the petitioners have appeared before the IO and recorded their statement. So, considering the nature of allegations so leveled against the petitioner herein in the FIR dated 15/7/2024 and also on perusal of the agreement as entered into by the petitioner with the Assam Food and Civil Supplies Corporation Limited, this court is of the considered view that the matter pertains, that the allegation so leveled against the petitioner is based on documentary evidences, and there would not be, and there may not be a need for a custodial interrogation of the petitioner's hearing. Also, accordingly, on a consideration of the entire matter and also on perusal of the case diary, this court is of the considered view that the interim pre-arrest bail as granted to the petitioners, wide order dated 5/8/2024 is to be made absolute. Accordingly, the petitioner, accordingly the said interim order, the interim pre-arrest bail as granted by this court wide order dated 5/8/2024 is made absolute subject to the following conditions. Petitioner shall cooperate with the investigation. With the above observations and direction, the bail application stands disposed of.
29.
29 lot has on interim with the case study with the medical reports.
There were other cases, similar matters from the same FIR.
Yes, madam.
Those have been disposed of,
No, madam.
No.
pending.
Pending.
When?
Madam, 2030.
As prayed for by the learned counsel for the parties, registry to list these matters again on 23/9/2024. Petition, 23/9/2024. Interim order passed earlier to continue until, continue till the next date of listing. Anything more, Mr. Doctor? Anything more?
No. I'm obliged.
30.
30 lordship CD has not been received.
Wait, please, your lordship. Lordship, this is for anticipated bail application, lordship. The FIR, lordship, will find on page 11, lordship. Case was registered under 304B, lordship. The prime ingredients, lordship, required for demand of dowry, that is absent in the FIR, lordship. 3 ingredients have to be fulfilled.
Is there a receipt?
Not received, lordship. Earlier, it was-
Mr. B. Sharma Lalit,
lordship.
B. Chaudhary, I know that. Mr. B. Sharma, Learned Additional Public Prosecutor submits that the case diary has not been received till date. Also, accordingly submits that the matter be taken up on
lordship 16.
16/9/2024. Also, on the next day, the case diary along with the postmortem report as well as FSL report be placed before this court. 16/9, na? 16/9.
Lordship, can it be elections because they have taken 3 days, lordship. On first, lordship, it is registered on 5/8. Thereafter, lordship, on 19/8, lordship.
Okay.
to the side.
Argue,
Lordship.
argue,
Yes, lordship.
argue. But I'm dismissing.
But lordship, I am for, they have taken time, lordship.
No,
That's
no,
why,
you
lordship, they have-
argue.
Lordship, they have taken time,
Mr.
lordship.
Counsel, you argue. You forget the FD, CD. We'll go by your material.
Yes, lordship, then lordship, can we come to the
But-
FIR?
I'll warn you, I'm against you.
Against lordship,
You
that last.
changed my view.
But it is
I'm
lordship.
tentative, it is tentative. Tentative view against you.
Lordship,
Now
that's
you
lordship.
change me.
Because of lordship, they have taken time, lordship, they have taken time because of the earlier occasion, this was rejected, lordship. That time postmortem report was not placed, lordship. Now, lordship, that's why this case was rejected in lordship 2022,
I know that.
lordship.
My Lord
That-
Justice Ajit Thakur's order.
Yes,
Yes.
lordship, that time, lordship, case date, he was there, lordship. Now, lordship, 3 days they have taken for placing the case date, lordship. 2 days I have taken to place the case date, lordship.
Okay, you argue.
Then after that, lordship, without lordship, that lordship.
Forget the case diary. We'll go by your statements. Show me.
Yes, lordship, may I read the FIR, lordship?
But I'm dismissing it. I'm against it.
Because lordship, that dowry part is not there, lordship. Dowry part is not there. All the family members have been lordship booked in this case, lordship. FIR was registered against all the
This
family
case
members.
is only with regard to Ajibur now.
Yeah, now Ajibur.
Forget the rest. We are not
case-
concerned with the rest.
Ajibur prayer was rejected, lordship.
We are not concerned with the rest.
Yes, lordship.
I'm only concerned with the CD,
Yes.
with Ajibur and the allegations
Yes,
And this court had perused the CD on the last occasion.
but postmortem report was not placed because lordship, here lordship, poisoning is there, lordship.
So have
Yes.
patience there on the next date. 16/9.
Obliged, lord.
33.
This court, where it finds something, it passes.
Yes, lord.
But when there is some gray area, this court will not proceed. Don't
Yes,
worry
lordship.
about it.
But my.
Your only thing is poisoning, yes or no, that will be clear from the FSL report.
Yes, lord.
We have to wait for that. Wait, be there. Earlier, your bail application was cancelled.
Rejected, lord. Highly honorable.
33 CD has been received.
What is that?
Lordship, here the-
Statement of the victim girl has been recorded?
Yes, Lordship.
What does she say?
She says, Lordship, that this petitioner, along with other accused persons, those are mentioned in the FIR also, Lordship. They have, Lordship, groped her, Lordship. In her death allegation is there, Lordship, but from the statement of the
But
other,
the FIR does
Yes,
not inspire confidence.
Lordship, from the statement of the other villagers, Lordship, they have stated that there was a village meeting and all these allegations are true against the petitioner, Lordship, that she had an illicit relationship with another person. Those person caught her and thereafter that meeting was held. So, Lordship,
Grant bill. Heard, Mr.
ABCD.
ABCD Learned Counsel for the petitioner. I'll pass this order. Give me the CD. I'll pass this order. Dispose of. We don't need.
Highly honorable.
34.
And the other accused have also been granted bail. Yes.
to my knowledge, Lordship, I don't.
Yes, yes. Bokul Ali, Bokul Sheikh and Monibul Islam. Mohibul Ali,
Granted.
right? They have been granted bail.
Interim,
Yes.
Lordship.
You have the order? Bail order.
No order available.
I think, Lordship, they were granted interim, Lordship, if I'm not wrong.
No. Finally. I'll just check up. Can you get me those orders?
No.
No. Why are you here?
Lordship, in the CD, there is an interim order.
No,
If we-
in
Not-
my note, it is, in my note it is said that bail order is disposed of.
Lordship, then from that interim order, Lordship, we can get the case number and we can check in the website.
It is 1157/2024. Write down. Get me 2 copies. 1157/2024 and 1285/2025. I think I have the orders.
AB.
My highly obliged.
May be, Your Lordship. In this
Just a
case,
moment, just a moment.
CD was called for. There is no interim in this case, Lordship.
I have it. I'll pass.
34.
Yes.
May be, Your Lordship. In this case, CD was called for,
Disposed of.
Lordship. There is no
Qualified.
interim.
30.
34, Lordship.
Yes. What is against Pradeep Das?
Allegation is, Lordship, if I may submit, Lordship, this is a 302 case. The husband, Lordship, who was found dead in his house, Lordship.
Husband dead, marpit by the daughter and the mother.
Yes. Now, Lordship, the allegation, whatever has happened, right? The neighbor's statement has been recorded, at least 5 or 6 witnesses. They have stated that he was all along been beaten by the wife and daughter. On that night also, there was loud noises coming from the houses. He was shouting bossa bossa and so on. In the morning, Lordship, an ambulance was called. The driver's statement has also been recorded before. This petitioner, Lordship, he happens to be the brother of
the wife.
Yes. He was there with them. They hurriedly took him to the hospital. They should have taken him to the Tinsukia hospital, which was nearest, but they instead took him to Dibrugarh hospital as per the statement of the driver.
Brought dead.
They were trying to blood stains from the house and ambulance.
The Pradeep Das also.
Yes. And Lordship, Lordship, further investigation is needed because.
And what happened to the mother and the daughter still behind
they were
bus?
arrested, yes.
Still behind the bus.
Yes.
Lordship, but from the FIR, there is no.
Okay, fine. FIR,
And
there is a doubt.
I made categorical statement.
I know that. I've seen it.
Incident, I rushed to my sister's house, Lordship.
No, no,
Just
that
to
if
get
you
one-
were also a party to
Just-
the destruction of evidence.
Lordship,
Accompany my
I may
sister-
just add
sister,
one line, Lordship.
sister's
The
daughter.
PM was done there, Lordship. That report is not in the case diary. His body cremated as soon as it was released. It was not even brought back to the house, Lordship.
And there is statements, materials to show that Pradip Das was
Yes.
also involved in
Yes,
the destruction of evidence.
Yes, Lordship. This statement of the driver, everything is there. If Lordship kindly goes to one statement,
Lordship,
Lordship, he has
Pradip-
stated
Had,
that
Lordship.
had Ms. R. Chaudhary, learned counsel for the petitioner, and also Mr. B. Sharma, learned counsel, raised it to list these matters on the prayer of the learned counsel for the petitioner after 10 days.
Applied.
then Lordship 14 days may be granted. We will need to update the case.
After 2 weeks. 2 weeks would be 19/9/2024. On the next date of listing, Mr. B. Sharma shall produce the updated case diary before this.
Okay.
Right. I'm against you.
35.
May I please, your Lordship? Could you have
Victim
fixed
girl statement receipt.
Lordship, love relation.
Oh. What does he say?
Due to torture of her husband, she escaped from her home with her boyfriend and then went to some place, Lordship. She voluntarily appeared before the IO, Lordship.
She. Oh, she is a married girl. She's a married girl. No.
No.
No, no, you said husband, voluntarily husband, what did
family
he?
No, Lordship. Father used to torture her. Lordship.
Her father.
Her father.
So she ran away with him. But Mr. Yes, your name?
PD Bhuyan.
PD Bhuya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional PP. So. Any interim order? No. So, the present application has been so instituted under section 482 of the Bharatiya Nagrik Suraksha Sanhita 2023 for grant of pre-arrest bail in connection with Azara PS case number 166 of 2024 under section 87 of the BNS 2023. So, a perusal of the FIR would go to reveal that the victim girl was alleged to have been kidnapped by the petitioner herein. Full stop. Mr. B. Sharma, learned additional PP, has produced the case diary. I have perused the same. So, the case diary contains the statement of the victim girl recorded under section 183. It would be BNS. 183 would be BNS. 164 equivalent is
183.
BNS.
BNSS.
BNSS. Also, wherein she has categorically stated that she was in love with the petitioner herein, and on account of that, she was subjected to torture by her father and by her parents. Full stop. And she has further submitted that she had eloped with the petitioner on her own sweet will. Full stop. The petitioner has further in her statement submitted that she wanted to proceed with her boyfriend, that is the petitioner hearing. So in view of the above statement of the victim girl, this court is of the considered view that the petitioner hearing is entitled to be enlarged on pre-arrest bail. So accordingly, in the event of the arrest of the petitioner in connection with Ajara PS case number 166/2024 under section 87 BNS 2023, he shall be released on bail of rupees 20,000 with surety of the like amount. Full stop. What condition? What condition should be there? The petitioner
Will
shall
cooperate.
cooperate with the investigation of the matter. Which shall cooperate, subject to the condition that the petitioner shall cooperate with the investigating officer in smooth conclusion of the investigation in the matter. Also, with the above observations and action, the bail application stands disposed of.
Lordship will just add one line of our objection also. Our objection.
Mr. B. Sharma vehemently objects grant of bail to the petitioner hearing and submits that further investigation is called for in the matter. Will do? Much of
That is required in every case. Lord.
Okay, done. Every case it will be there. Even where I don't pass an order of bail.
Supplementary course list bail hearing, item 63.
Wait. This case, the case, they was called for.
Huh?
Item number 63. Lordship.
63 matlab charge sheet submitted.
Okay, charge sheet submitted.
Yes.
Madam.
Appear, go for bail, regular bail.
I'm on interim. Lordship.
Huh?
I'm on interim.
Till the appearance. Madam.
Huh?
Till the appearance.
We'll protect you.
Yes.
Also, heard Mr.
P. Doctor. Lordship. P. Doctor.
P. Dr. Learned Counsel for the petitioner. Also heard Mr. K.K. Parasar Learned Additional PP. Also, Mr. K.K. Parasar Learned Additional PP submits on instructions that the charge sheet has been filed in the present case. Also, accordingly, the petitioner hearing is directed to approach the trial court.
CS number matlab 132
Charge sheet has been submitted by CS number
132/24
132 of 24 dated
206/24.
206/2020. Accordingly, the petitioner is required to approach the trial court
Yes, sir. Yes.
for a regular bail. Also, till the petitioner within a period of 15 days from today. For the next period of 15 days, the interim order passed by this court wide order dated 24/7/2023 shall continue to hold the field. Okay? For 15 days, we are protecting him.
Yes.
Mr. Parasa,
Hello.
15 days. With the above observations and action, the bail application stands disposed of.
64, 65.
Remember this matter which came up day before yesterday?
Hmm.
Because of the marital discord, the wife had committed suicide and they had projected it to be a case of murder.
Yes, what is that?
Matlab yes, postmortem report matlab
Suicidal.
especially as a result of suicidal hanging matlab and non-continuous ligature mark.
Hmm.
But there are some injury in the face.
Hmm.
As per the PM report also, the injury sustained on the face was antemortem caused by blunt force impact and was simple in nature. There are two petitions. One is 64 is the husband and others are the family member.
64 is husband.
Husband.
We are
Ah.
on 60, I'm on 65 now.
And who is for 64?
60.
Others family members were not at that night. Family members went for a village function at that night. Morning they came to know that door lock and she committed suicide. And they have also appeared. They are on interim. They have appeared. But regarding 64, I have objection. 60 husband, he is in the house.
He was in the house. You are for?
In-laws.
Appeared,
Heard.
S. Nawaz.
Yes?
S. Nawaz.
As Nawaz, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned additional PP for the state respondents. Also, The present application has been filed under. This is under 438.
438.
438 of the Code of Criminal Procedure 1973, praying for grant of pre-arrest bail in to the petitioners, accused petitioners, in connection with Abhaipuri PS case number 79 of 2024 under section 302/34 IPC. Also, this court wide order dated 13/5/2024 on considering the materials available on record was pleased to extend the privilege of pre-arrest bail, interim pre-arrest bail to the petitioner's hearing. Also, it is contended, that the petitioner's hearing have thereafter, in terms of the directions passed by this court, appeared before the investigating officer and has recorded their respective statements. Right? All of them have done
All four appear.
statements. Full stop. It is further contended that the petitioners have not misused the liberty granted to the petitioners in the form of interim pre-arrest bail by this court, widely said order dated 13/5/2024. Also, further, the CD reveals that on the date of death of the deceased, the petitioners hearing were not present.
They went in the night.
Had gone
village
for a
function.
village function and
Came
had
in late
returned in the morning.
Return in late night.
And had
came to
returned
know
late
about the
night
incident in
and
the morning.
accordingly had come to learn about the death of the victim, of the deceased by way of hanging only in the early morning hours. Also, in view of the above position, this court is of the considered view that the petitioners herein have made out a case for being granted pre-arrest bail, and accordingly, the interim pre-arrest bail as granted by this court, wide order dated 13/5/2024, is made absolute subject to the following conditions. Condition number 2 and 3. With the above observations and directions, the bail application stands disposed of. And what about 64?
64, my lord, father, in the petitioner in the in other case, my lord, father of the father-in-law of the deceased. He also stated that sometimes he has quarrel with the husband, but some mark in the face, and it is also in the PM report that some injuries in the face.
Who is appearing?
Oh, Roshni.
E. Begum Paresh, my lord, she had appeared on the last date.
Check up.
I can inform.
Dutta was at Matiba.
Yes, ma'am.
65 to dispose COVID 60.
65 disposal, madam.
65 to dispose, 62, 64 to 2 p.m.
At 2, my lord.
The number?
Name support. It will call at 2, madam. Before at 2.
64, keep it at 2.
Yes.
Orders item 36.
R2 has been served. Respondent number 2 has
Yes,
been
sir.
served, but nobody has entered appearance. So we'll have to appoint an amicus. We appoint or the registry will appoint?
Registry.
Also, seen the office note dated 2/9/2024, the service upon respondent number 2 is held to be complete. Also, however, there is no representation on behalf of the said respondent number 2 and no. However, it is seen that no advocate has entered, no counsel has entered appearance on behalf of the respondent number 2. Also, in view of the above position, registry to engage amicus curiae for the respondent number 2 and also list this matter again on after 3 weeks. After 3 weeks,
So, short date मतलब
2 weeks,
हाँ, 2 weeks.
2 weeks. Also,
37.
Filing number.
Lordship, leave may kindly be granted.
yes, what is your objection in granting leave?
My senior is lagging in code A.
That is your objection. Huh? If that is the objection, then that's a very valid objection.
May kindly be granted.
Who is your senior?
Ardhar.
Okay, call him. Let him come.
$38.
Lordship, as per the last order, respondent number 1 and 2's name had to be reflected. And as per office note dated 29/8, the names have been reflected.
Yes, what is to be done today? Admitted. Admitted.
Yes, Your Lordship.
We can have it for hearing.
Yes, Your Lordship.
But the learned counsel for the parties. The service upon the parties is complete. The lower court records has also been received accordingly. Registry to list this matter again, list this matter for hearing. When? Hearing
After the vacation, puja
Huh?
vacation. After the puja
After
vacation.
puja.
in the month of October 2024. Publish.
40.
Yes, Mr. Bonik, after a long time.
Lordship had heard this matter, my lord. Lordship recalls this man had demolished his own house on the thing that
Jal Jeevan.
the scheme was there. And there was nothing on record to show that he had any enforceable right to stake a claim. My lord, the gentleman who was there with me, he's suffering from chicken pox, the council member. So I do not have any further instructions as of now. And obviously they have a stand against us, correctly so. But may I pray in all fairness, I know there is nothing in the matter. Let them put on affidavit. Let it be on affidavit.
What?
So, let the stand be on affidavit.
No, no. My recording is standing.
I agree so.
We are dismissing it.
A lot. On the ground of enforceable right.
On the ground of no foreseeable right. Yes.
Lordship, this is stand, there was no document to show, there was no intimation he made to us whether he wanted, even he is a beneficiary of another scheme, Your Lordship.
Just give me a single sheet note on that.
Very well, Lordship. That
Single sheet note on that. When? Tomorrow?
tomorrow, Your Lordship. Day after tomorrow, Your Lordship.
Day after tomorrow, I'm not coming.
No one.
Tomorrow.
I'll not let my Saturday go. Tomorrow, whatever is there, we'll have it on Monday and I'll pass the order.
No, Your Lordship.
Heard the parties at length, list this matter again on Monday, 9/9/2024 for delivery of orders.
Obliged.
Give me that.
Very well.
Tomorrow by second up you can give.
Very well.
Obliged.
Obliged.
Sorry, Mr. Monik.
41.
Oh, 2000.
42.
2 p.m. 41 at 2 will be.
May I please, Your Lordship?
Oh,
Lordship, in this matter, we have ready to quash the impugned orders dated 15/12/23 passed by the Session Judge, Nagaon, and order dated 13/10/2023 passed by CJM, Nagaon, in NI case number 4720, Lordship. In this matter, whatever Lordship, the respondent had filed a complaint case against the
Just a
petitioner.
moment, madam, just a moment. Private respondent, who is appearing? Respondent number, sole respondent, Mustafa Hussain. He has not entered appearance till now. Mustafa Hussain has not entered appearance.
No, Lordship.
Low court records, record is in you. So, peruse the office note dated 30, Lajima Court order dated 30/8/2024. Also, the service upon the sole respondents is held to be complete. Also, it is seen that the lower court, that the LCR has also been received. Scan copy of the LCR has also been received. Accordingly, registry to list this matter again for admissions on when?
Lordship, till then, the orders may be stayed up to.
He has been just, there is a note on 38. Wait for a date. We'll have it on 16/9/2024. On that day, we will pass. The admissions, let it come, we'll pass on.
Till then, orders may be stayed, Lordship.
On the admission date, next date, renew your prayer.
Lordship, it would be infractious of the Lordship otherwise.
Will not be. We'll give you a shorter date. We'll have it on 10/9.
10/9.
10/9. You renew your prayer on that day.
43.
Mr. Bhuya, you are for that matter. Get hold of Mr. Nat. 40. None appears for the petitioner on call.
Delay
40.
confirmation.
Applicant on call. 260 days delay. Statutory appeal? No. Criminal revision. For the ends of justice, raised it to list this matter again after 2 weeks on the 2 effects.
44.
For continuing the delay of 80 days in preparing criminal revision petition.
Heard Mr. M.S. Ali, learned counsel for the petitioner. Also heard Mr. K.K. Parasar, learned additional PP. The present application has been so instituted, praying for condonation of a delay of 80 days in instituting the connected criminal revision petition against the judgment and order dated 12/3/2024 in criminal appeal number 2/2022, passed by the Court of the Learned Session Judge Baksa Musalpur, Assam. So issue notice, returnable 4 weeks. Mr. Parasar accepts notice on behalf of the respondent number 1. Full stop. Petitioner to take steps for service of notice of the respondent number 2 by way of registered post with AD. Steps within 3 working days from today. Registry to list this matter immediately on conclusion of 4 weeks from today.
Highly applicable.
45.
Yes, Mr. Dotto.
This case, the CD was called for, just regarding the allegation is that someone.
Up to date, CD.
Yes, CD not received.
Heard Mr. M. Dotto, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned additional PP. Mr. Parasar submits that he be given a further week's time to place on record the updated CD in terms of the earlier directions passed by this court. Also, registry according to list this matter again on when? Hadgaon?
Hadgam, yes,
12/9/2024 for production of the update. Madhya.
Timing 10.
Yes, Mr. Chaudhary.
Lordship, I apologize. There was the serious matter in division bench, Lordship.
Busy lawyers, we know. Then what happened? Now tell me. This one, what is going on?
Lordship, here the main act that virus of the Entry Tax Act, that series was there in the court
Okay.
number 5.
Hmm.
And Lordship here, Lordship on the last occasion has asked me for the records. Lordship, it's not traceable since it's an old record. They are
Then-
trying it.
Then?
But
Then?
Lordship.
Then?
Then Lordship, otherwise Lordship, both of us have given our submission, and only my humble prayer will be that set-top box and encoder has been segregated because they cannot work alone. They are not on wireless equipment. They has to be connected with some other equipment. Then only because it's decrypt the signals that it receives, Lordship.
I wanted the basis of the issuance of the impugned order.
Yes, Lordship, that's true, but that file they are not
Why?
difficulty, Lordship, because they are. Otherwise, Lordship may give me one more chance on Tuesday if Lordship they can find it.
Then how did you file this affidavit?
Lordship, it's
This was filed in 14.
14, Lordship.
So this case was pending. You knew
Yes.
about it.
Yes, Lordship.
So
In
the
14
records
the-
could not have been held to be, cannot be said to be misplaced. When were the records misplaced?
No, but Lordship, they can't even say whether it was misplaced because it is not traceable, Lordship.
But this affidavit was filed
Yes, Lordship, maybe.
and
till
there are
that
at
point of
least
the-
3 paragraphs from record there.
Yes, Lordship, on 12/9/14 it was filed. Lordship, maybe till that time it was there, maybe 2 years back also there, maybe that all maybe will come up, Lordship.
Okay. Give me a written submission. Whatever is there, just put it down. I don't want to hear it again. I've already heard it, so just give me a written submission. You also make your written submissions.
And
When?
if Lordship, 1 week.
1 week, Thursday, for both record as well as the written submission. Just
I-
take me through that and we'll close the matter.
And Lordship, if in the
We'll have
meantime
it next Thursday.
if in the meantime I get the record.
Mr. B. Chaudhary, Learned Standing Counsel, Finance and Taxation Department submits that he be given time till Thursday next to enable him to enable the respondents to trace out the records, concerned records, which he states is missing. For some. Prayer accepted. the parties are also at liberty to bring on record their respective written submissions on the next date of listing. Also, accordingly, raised it to list this matter again on Thursday for further hearing.
Let it be on the top of the list.
Huh?
Let it be on the top of the list.
Huh?
Let it be on the top of the list.
It is top of the list, but it's a criminal bench, so it will have to give preference to the criminal. Don't worry, you just make a mention in the month.
Deeply applied.
Hearing item 46.
Yes, Mr.
Here, I have gone through the records, but one difficulty I have, my officers are also here. Just to get one clarification, I need one more day time.
You have your time. We will
bills
give
are-
you the maximum time you want.
The original bills are the bills which they have submitted. These are not here. They sub. That
Why?
said,
Why the original bills are not there?
no, it is in the other.
Okay, another file.
It is in the other file. They said, some queries have, Lordship has raised some queries, otherwise, as regard the note sheet, whether the department decided to, when the department decided to pay the claim amounts, any further decision reviewing that I have.
You do one thing, to make it more smoother for
Lord.
both of us,
Lord.
as well as for the petitioner,
Lord.
whatever clarification we have sought for, give it. I don't want an affidavit. At least some of your officer, any of your officer, competent officer,
Yeah.
he can give it in a written form of instruction to you. You can
Lord.
place that before us.
May
No,
I
in the-
submit
in the
now
record-
to your lordship's permissions, my lord. That much of indulgence I am asking for.
You are at liberty to take the maximum indulgence you want, Mr. Singh. Go ahead.
This was, my lord, what I am on. The FO is being considered as the financial head with regard to every government. I have quoted his financial, whatever is been in the note sheet.
Mr. Bhuya,
Thereafter being
Mr. Bhuya,
spending, my lord,
Mr.
for
Bhuya,
this ground, that ground.
Mr. Bhuya, my last
You be-
order,
Yes,
I have brought everything.
absolutely.
Yes.
And my lord, I am
Mr.
producing
Nath,
My
Mr.
documents
Bhuya.
also, my lord.
Mr.
They will
Bhuya.
take look at it, my
No,
lord.
no.
Because
first-
they may raise it, my lord.
No, first let us get over with this.
Yeah.
And Mr. Bhuya, I understand Mr. Nath's predicament because he cannot take a decision on his own. He'll have to depend on his officers.
Well,
And you know how things work.
yes.
So we will give him one more date. That's why I'm saying we will get the queries that I have raised answered in a form of an instruction to him from the officer. You can place that before me. That will clarify everything.
The FOW's note that I have seen, and FOW has given a subsequent note that I have flagged. It is
Mr. Nath,
I'll-
please bring those things on record. That's all. You get it in writing, whatever queries I have raised.
Yes.
As a reply, you just give it to me in writing. That'll do.
Lordship,
Then we will see what can be done.
Madam.
But as far as we are concerned, with the materials before us today, we are convinced, at least tentatively, that the petitioner has made out a case.
Officers note that what the
Now,
petitioner is
now you show me
Yes.
the additional materials which are not before me,
True.
which I have not
True.
seen.
True.
That is what you have to do.
Yes, I'll place it.
The material Mr. Bhuya has placed and whatever I could go through, I have found that, see, 12 was not there, it was only 6. The producers or the director, whoever has created, his statement is there that the things are with me, take it from me. You have never taken it. FOW's note is there. His bills have been given. Corresponding bills of the telecasting channels are there. So, prima facie, something has been made out.
Clear.
You
I'll-
just take me out of that.
Lordship,
Right.
I'll clarify.
On the prayer of heard Mr. A. Bhuya, learned counsel for the petitioner, also heard Mr. D. Nath, learned senior government advocate, appearing for the state respondent. Mr. Nath submits that he be given a further week's time to respond to the queries as raised by this court-wide order dated 16/8/2024. Also, the said prayer, although objected to by Mr. Bhuya initially, Mr. Bhuya, however, has submitted that the same be brought on record in a written form. Also, Accordingly, Mr. Nath shall receive the instructions to the queries in written from the competent authority and place the same before this court on the next date of this law.
Next date, my lord.
Or in the form of an instruction, not even if not in the.
No affidavit. You
Lodge.
give me that much, Mr. Nath, we have confidence
I'll
on.
place.
That you don't worry.
I'll place.
Again, affidavit will take another month.
A
Sometime.
copy may be also given.
That we will see.
Lodge. Lodge.
When?
Well, they said 3 days time is required, or Tuesday or Thursday, lodge may take.
Thursday.
Lodge.
Thursday.
Thursday,
You're free?
my lord. Thursday.
Check up.
Yes.
Some maybe bigger suitcases may be waiting somewhere.
Like that, my lord. 30. Only 13th I'll be out of station, my lord. Rest I'm there. Any other.
Thursday is 12.
12.
Yes, I'll be
12.
there.
12.
Deeply
We'll try to
organized.
give it a closure, at least if not on that day, on the next day, we will close it.
Lodge.
Yeah.
Let us have the complete things on record on 12th.
If I am entitled to. I
He'll
should
get it.
that's
Otherwise,
all.
we'll reject it. Don't worry.
Obligement.
In this case, B. Sharma was amicus curiae, he was there, but CS is not well. He has informed me telephone.
It has been submitted at the bar that the amicus curiae so engaged in the matter is not well, is indisposed, and accordingly, a prayer has been made for adjournment of the matter. Prayer accepted. The criminal, the matter be stands adjourned till 29/2020. Adjourn, register to list, adjourn, register to list this matter again on 29/2020. Yes.
May I please, your lordship, this matter may kindly be taken up at 2, your lordship. It will.
Yes. What is the issue?
My lord, the order was challenged as allowing, my lord, the witness to be re-examined along with a document to produce, fresh. And that I have challenged the order. Under section 311, it was issued, and my case is that he can be re-examined, but the document which was not placed before the police, and it was not seized by the police, now the court cannot take up that into evidence, that document. Because the purpose in this case arose out of a FIR and police investigation. It is not arose out of a complaint.
Oh, it's a police case, jail case.
Yes. So that was not, and he admitted also. He admitted also, it was not placed before the police. It was not given to the police. Now he wants it to be, my lord, executed.
Is it permissible?
No, my lord. That
Is there decisions on that?
Here, High Court, there is a decision, my lord.
Our High Court. What is that?
2008 Court GLT.
Just show me.
My lord, para 11. My lord, para 11, your lordship may kindly.
Visible.
Para 11 is specific, my lord.
Okay, 2 p.m. দুটা বজাত দুটা বজাত মানে সেই সিরিয়ালি মাতি যাব there are few matters top will finish it and come back Yes, ma'am.
My senior is out of station. That's why I need some day.
Have you
Kindly-
informed him?
Kindly matter fix.
No,
for-
did you inform him beforehand?
Yes, yes.
When? When did you inform him? Senior person, when did you inform him? That you are not, you will be praying for an adjournment today. When did you inform the learned counsel body petitioner? When?
Today only.
Then? Why? He prepared the matter yesterday. He is waiting here from the morning. I've seen him. I was about to ask him why. Then I saw his name. So I just thought I'm reaching the matter. This is not done. If you're not doing the matter, at least you must inform your colleague. Who is your senior?
FKR Ahmed.
Yes, Mr. Das.
No, this, in this case,
We'll have it on Tuesday.
Yes.
We'll have it on Tuesday. And we'll proceed with the hearing because some difficulty. We will not put her to difficulty. We'll have it on Tuesday. On the prayer of the learned counsel for the respondent. Raised it to and not above respondent. Raised it to list this matter again on 10/9/2024. 10/9/2024. So we'll have it on. I've gone right. We'll have it on Tuesday. And next time, if you are praying for an adjournment, inform the council at least a day before.
Yes.
Here, my service, upon responsibility is complete but not appeared. So am I case to be appointed, my POXO matter.
POSCO matter. The registry will have to appoint or I also seen the office note dated. Where did you, how did you know that this is complete?
Yes, the registry order is there.
Huh?
Order is.
I put this court order or registry's note?
Note is there.
I was trying to find that. Huh?
Like as SR. S. Hard scan copy lot.
In another file, maybe.
Another file lot.
Hey, 405 just second file.
S.
Oh, this file I did not find that.
Like as SR. Yellow mark flag.
No, that's not. Lokidas, perfect case also.
Lucky that.
Also. It is seen from the records that the notice has been served upon the respondent number 2 on 12/1/2023. However, there is no representation on behalf of the said respondent before this court today, when the matter is called up today. Accordingly, registry is directed to appoint an amicus curiae, engage an amicus curiae for the respondent number 2. And thereafter list this matter again on, we'll give at least 2 weeks time on 23, on 24/9/2024. Right? Any problem? Second?
24.
24. Right?
23 by law.
23/9/20.
Obligement.
hello. That, item of 51, it may be given 12 minutes. I got 2 other cases on 10,
Okay, when do you want it?
12 minutes.
Hey, item number 50?
1.
1. 12. 12. When do you want it? Forget them. When do you want it? 12.
Either 11 or 12, my lord.
When is it convenient to you? Don't listen to her. You tell me when it is convenient to you.
11,
Huh? 11, 9.
Okay, thank you. Allah.
So she prevailed.
Is an appeal against conviction, your lordship. 8 years of conviction, your lordship. And 4 years is already done, your lordship. Record is there, your lordship. LCR. 10 cases of ganja recovered from two accused persons, your lordship. I am representing one.
Who is for the other one? R. Burwa.
Our
They are not same FIR, same transaction.
same. Both of us were, your lordship, picked up from the train station, your lordship. And 10 kg, your lordship, is greater than
Small quantity.
small, but lesser than commercial.
Commercial.
Intermediate quantity.
So the punishment would be?
10 years, your lordship. 8 years was given, your lordship.
No. If it is small quality, it is 1 year.
Lordship.
And intermittent quantity between,
Your lordship will get it at
just check the notification.
which shall not be less than 10 years. But
For commercial.
not, your lordship. 20B, your lordship.
20B is, 20C is commercial.
Lordship.
Ah.
20B. But greater than small with rigorous imprisonment which may extend to 10 years, which are fine, which may extend to 1 lakh rupees. 10 years. And 8 years, your lordship.
Material seized from your possession.
Your lordship, from a bag, your lordship.
So 50 bag.
From whose possession, your lordship, this has not been.
So 50 will not.
Lordship.
50 will not commit.
But your lordship, there is violation of 52A. Your lordship. There is no, your lordship.
Ganja.
Lordship.
Ganja.
Ganja, your lordship. 52A, your lordship, is there is violation. The sample, they have not produced any documents, your lordship, by which the compliance, which shows the compliance of 52A. Your lordship. Inventory was, your lordship, certified by the magistrate was not exhibited, your lordship. The samples were not, your lordship, collected in presence of the magistrate as required under section 52 and as has been held by the mandatory to be held by the Honorable Apex Court as well as this Honorable Court. Your lordship.
What were the FSL report? How are the samples denoted to have been received?
That, your lordship, they said, your lordship, they have received on 4th, your lordship. It was
FSL.
FSL. And your lordship, who took it, your lordship, where from 1, your lordship, to 4, your lordship, where it was, your lordship, these were not reflected from the evidences.
Okay, material was seized on 1st. Ready for sending to FSL on 4th, received by FSL on 4th.
Malkhana
to
register
4th.
was not produced to exhibit.
After seizure, there was no
From
production.
1 to 4, there is no explanation.
And when was it before the magistrate?
No, that is not there in the record, your lordship.
Huh?
Your lordship will find, your lordship, in the. In fact, your lordship, the procedure as per 52A is, your lordship, immediately, your lordship, this would be sent to the police station, your lordship. Then he will submit an inventory and an application for collection of getting a
Sample.
certificate, your lordship. That has not been followed and that has not followed, that has not been brought to record, your lordship, by whoever.
Yes, Mr. Parasar.
Malat, regarding that, Malat, I had to go through the LCA, Malat. Today I have not yet done from Malat. And one thing is, I
I not concerned, we are not concerned.
We'll go for the main appeal now.
main appeal.
So these are the
These
points.
are basically points, your lordship. I have some judgment, your lordship, to rely upon, your lordship.
Section 50 out of the way, not from your possession.
No. But
You say that the
42 is there, your lordship.
42A.
Recording of the source, it is based on source information. your
Ah.
lordship.
They will have to record it, your lordship.
Fine,
Now,
that we can look
Yes.
into, but
But
you say-
essentially, my case is 52A.
52A, you said although the material was seized, the requirements of 52 magistrates, drawing of sample, sending to the FSL,
FSL.
4 days gap.
Yes. And that is fatal, your lordship, in my humble service.
And the materials were coming
absence
from?
of explanation.
Materials were coming from?
Your
Where was
lordship,
it seized from?
seized from the railway station, your lordship. And your lordship, it's very interestingly, they have not said from whose custody, your lordship, it is
Seized.
seized.
Because it's in the bag.
It's in bag, but whose hand the bag?
How were
was?
you and the bag connected?
No, your lordship, we are dropping together, your lordship. We are coming from the same,
No, no, you say it
by
was,
the same train, your lordship,
I know that. You were together.
together.
So this whole transaction, you both were acting in partnership.
According to them, your
No, no,
lordship.
no, according to you.
No, your lordship, not,
So these were individual seizures.
no, they will have to come up with a specific, your
I'm
lordship,
coming to that.
lordship.
Individual seizure made from you, made from A, made from B. It was in the same train. They say it is together, so commercial quantity.
Lords.
You may have to, you may make a system. No, it was a quantity specific to me. If that is taken, then it will be lower. So punishment would be, what did the learned trial court say?
Now, your lordship, the court has not gone into that aspect, your lordship. First of all, your lordship, they will have to say that from whose custody they have recovered the bag. That is not clear. They only vaguely say that from both of them, the bag is recovered, your lordship.
Only one bag
One bag,
between two people.
two people here. They will have to come up with a specific.
So it's not the other way around. Both
No.
from, there was no two bags. One bag from two
One
persons.
bag, your lord.
One bag of 10 kg.
When? Tuesday.
Hello.
Tuesday.
Well, good.
On the prayer of Mr. I heard Mr. S. Bothakur, learned counsel for the petitioner. Also heard Mr. K. Parasar, learned counsel for the learned edition PP. On the prayer of Mr. Parasar, learned Mahasar, registered to list this matter again on 10 or 13. 10,
Or
12,
10.
10, 12, 10, 10, 10, 9.
Possibly keep it as part of it.
No, no,
Come up in the top of the list then. your
no, no,
lordship.
no, I can't, because
Other
I don't
than
know. I should be there next week, but yeah, I may not be also. So
No, that is not.
I'm finding it interesting now.
Lordship.
Yes.
Deeply obliged.
দুটাই দে 66, 67 দুটা দোনো হা আৰু
May I please, your lordship, with respect to item number 36, actually, your lordship, I was in a different court at that time. My presence may be recorded, your lordship.
you are for?
Item 36, your lordship.
You are
I'm
for?
the petitioner, your lordship.
No, we have only said that the amicus be appointed for respondent number 2. 36 तुम लिया था क्या?
My presence may be recorded.
Your name?
R. Kumar, your lordship.
R. Kumar. 36 কোনে লৈছিল? অনামিকা কৈ দিবা হে R. Kumar, learned counsel for the petitioner বোলে.
Obliged.
Non APS বোলে লিখিছো সব এটা কাট দিবা.
Lordship, Miraz Ali was arrested by police sent to observation. Miraz Ali was arrested by police and sent to observation home.
Okay.
Later on, got bail from JJB, learned JJB. In case of maintainability, my lord, if there is any.
No. That is the juvenile, it will be maintainable. That is clear. You are 17 years old. It will be maintainable. Yes, what to do?
Yes, my lord, now he is placing a certificate by way of an additional affidavit.
They're not on that. We'll be on the crux of the matter.
Yes.
You have anything?
There are materials against the accused person. Initially, when Miraz Ali arrested, was apprehended, although he was, my lord, at that point of time 17.
What is the statement made against him?
Against him, that my lord, along with Miraz Ali, both this person named Miraz Ali named.
Okay, Miraz is gone. Let him also go. He will appear.
Yes. Ma'am.
This is AV.
Yes.
He will appear before the police.
Yes.
Okay. What is the name of him? Miraz. Miraz.
Miraz Ali.
M-I-R-A-Z.
MIRS.
So how is Miraz Ali is the main one?
Miraj Ali. Yes.
Miraz Ali is main.
Yes, initially he was arrested on the
Hmm.
basis of the all this information available with the police and thereafter.
Arrested, statement, petitioner, right?
Yes.
Disposed of, the file to move.
Bibliography.
क्यों है तो दिया भाई थी ऑर्डर ऑफ दिया एक कॉपी दिया
Wait, sing. Hmm. We'll pass similar order. Duta was at DD. 2 o'clock we'll pass the order.
Obliged.
And 41.
May I pleasure.
Yes.
483 application lodges, petitioners behind the bar last almost 38 days lodges. Allegation is so-called serious allegation lodges. FIR
case diary received, my lord.
Ah.
PM report also received.
Hmm.
PM report is not conclusive regarding cause of death, my lord.
Hmm.
As per opinion of the PM report,
Hmm.
my lord, cause of death is kept pending till receipt of chemical examiner's report from DFS Kahili Paramal.
Yes, Lordship. In this case, Lordship, the petitioner is behind the bar along with her 2 years milk-sucking baby, Lordship.
See, she is also been alleged to be responsible for death of a very young boy.
But on the dead day, Lordship, she was not present at the place of the occurrence, but he was in the.
She had come, allegation of the FIR.
Yes, yes, Lordship. Lordship, FIR.
How long will it take for the,
My lord, 10 days time may be allowed. I will try to get.
Mr. Sanjo Lanan additional PP submits that the postmortem report is available in the case diary. However, the same is not conclusive and the authorities are awaiting the chemical analysis report from the Forensic Science Laboratory, Guwahati. Forensic Science Laboratory, FSL report.
Yes,
Forensic
FSL.
Science Laboratory. They were awaiting the FSL report to ascertain the cause of death of the deceased. So and he submits that the same would be available within a period of 10 days from today. Accordingly, registry is directed to list this matter again on 17/9/2024. The case diary be written and an updated case diary with the conclusion as to the death of the deceased be placed on record on the next day.
17 lots.
17/9.
17.
Yes.
May I please, your lordship? Plus, in this case comes in orders column, lordship. Lordship, answer notice is returned, lordship. But the report of the district magistrate yet to come, lordship. Passing of the FIR, lordship. CD also not receive. CD also not receive, I think.
Registry to list this matter again on 19/9/2024 with an updated status report with regard to the notice served, notice issued to the petitioner through the district magistrate Sunitpur.
So can be on 17, Lordship, or 19, I have some difficulty.
Let it be on 20th, 20th, 20.
Yes.
24.
Heard Mr. A. Lanak, counsel for the petitioner. Also heard Mr. Parasara, who will be appearing?
Yes, keyboard have one.
Yeah, Mr. P. Bhattacharya, Lanak, additional PP appearing for the state respondents. So the present application has been so instituted by the petitioner, praying for pre-arrest bail in connection with Jalukbari PS case number 178/2024 under section 120 bracketed B oblique 420 oblique 392 oblique 34. Also, a perusal of the FIR dated 1/4/2024, leading to the registration of the above noted Jalukbari PS case number 178/2024 would go to reveal that one Bhapikas Deka had snatched the goods which were brought for delivery by the courier service personnel and had fled away with the said goods. The case diary as produced by the learned additional PP in the matter today reveals that the investigation in the matter led to the arrest of one Miraj Ali. Also, and it is from his statement that the name of the petitioner of being accomplice in the matter came to light. Also, it is stated that Miraj Ali was subsequently granted bail by the juvenile court, by the jurisdictional juvenile court. Also, I have perused the materials available on record as well as the materials contained in the case diary. Also, the goods have been recovered.
Yes, my 2 lakh, my sub 2 lakh 30.
It has been noted, it is
My lord,
revealed that the goods as well as certain cash amounts
from the residence of the present petitioner.
have been also recovered from the
2,93,000.
residence of the present petitioner. Also, although the learned counsel for the petitioner has submitted that the amounts so recovered have since been given in Jimma of the father of the petitioner. Also, in view of the above position and also considering the age of the petitioner herein, this court is of the view that further custodial interrogation in the matter may not be called for, and accordingly, it is provided that the petitioner is entitled to be enlarged on pre-arrest bail. Also, in the event, consequently, in the event of arrest of the petitioner in connection with Jalukbari PS case number 178/2024 under section 18, the petitioner shall be enlarged on bail shall be released on bail of bond of rupees 20,000 with like surety, appear before the investigating officer, corporate, or with the above observations and the bail application stands disposal.
My lord, one Miraj Ali, who was initially arrested, police after, my lord, he was sent to observation home because at that point of time he was juvenile. Whether he was granted bail or not, that is
Okay.
not reflected in the case.
Bail, Miraj Ali arrest bail there to
He was sent to observation
from
home.
his name, yeah, and sent to observation home. Bail, yeah, bail or okay.
33.
Heard Mr. A.B. Siddiqui, counsel for the petitioner. Also heard Mr. B. Sharma, additional PP. So the present application has been instituted by the petitioner praying for pre-arrest bail in connection with Kokrajhar PS case number 37 of 2024 under section 354 of 376 of 447 of 294 of 506 of 34 IPC. Also. What is the name of the petitioner herein, along with 3 others, were named as accused persons by the informant in an FIR lodged in a complaint case instituted by the complainant. Full stop. The said complaint case came to be registered as Kokrajhar PS case number 37 of 2024. Also, in the said FIR and the said complaint case, it has been denoted that the accused number 1, Derek Bukul Sheikh, had molested the petitioner, the informant, and subsequently the other accused person, including the petitioner hearing, had arrived at the place of occurrence and had also molested the informant, a complainant. Full stop. The said incident was stated to have so occasioned on 1/1/2024. Full stop. Thereafter, after a lapse of around a month's time, the complainant had instituted the said complaint before the has instituted the said complaint, which was subsequently forwarded to the police of the Kokrajhar police station and leading to registration of Kokrajhar PS case number 37 of 2024. Also, I have perused the materials available on record and also the case diary as produced by Mr. B. Sharma, learned additional PP. Also, Mr. B. Sharma at the outset has objected to the grant of bail, pre-arrest bail to the petitioner hearing, and has contended that materials, incriminating materials against the said petitioner is available in the case diary. Also, Kishore, you have a mic. Disposed of. Case diary is returned.
37.
Mr. Sharma, take this back.
Lordship, please may kindly be granted.
Was used to be delivered. Was used to be documented.
Leave may kindly be granted.
Yes, what is your objection?
Lordship, we don't have any objection.
The present application, interlocutory application has been, criminal leave petition has been so instituted, praying, seeking leave by the applicant herein for institution of the connected criminal appeal, SALE, and order, judgment and order dated 31/2019 passed by the Judicial Magistrate First Class Baksa in Musalpur in CR case number 103/2018. Also, I've heard the learned counsel for the parties. Also, the learned counsel for the respondent number, respondent number 2 has submitted that she would have no objection in the present application being allowed and leave granted to the applicant for institution of the connected criminal appeal. Also, accordingly, on consideration of the matter and also appreciating the submission so advanced by the learned counsel for the parties, the present interlocutory application is allowed and the applicant is granted leave to institute the connected criminal appeal against judgment and order dated so and so, so and so. No. Also, with the above observations, the interlocutory, the criminal leave petition stands disposed of. Criminal appeal. Criminal appeal. In view of the order passed today in criminal leave petition number 32/2019, registry to register the present criminal appeal and to list the same after. List the same. Is there a delay? Delay, na?
Already gone.
Condone. List the same for admissions after a week.
39.
Yes.
Very pending appeal on it. E76, my lord, I find 1 year, 3 months, my lord, 5 months, more than 5 months. And I find my lord from the evidence of consenting party.
Who is appearing for the respondent number 2?
No, respondent number 2 is not.
You are appearing?
Yes. I find she's a married lady, my lord, having 1 6-year son. And litigation is entered. And then she asked why you have entered my home. He says, I will take you to marry. So it amounts to my consent, what I find from the subject of your lordship and my learned friend say, my consenting party. But ultimately, my lord, I think it is not a case of conviction or a case 76, my lord.
Oh, you have given me a compilation.
Yes, I have done compilation.
Okay. What is the name of the appellant here now?
The list of that will make clear, my dear.
Sofiur Rahman.
Sofiur Rahman. List of dates, just your last name is list of dates. Occurrence 18/7, my FIR after my your loss was 23. After 5-6 days, 5 days. And
Page?
Page 1, your loss.
I have seen the FIR.
FIR. Now your loss can see, so if you enter my house, then your can see 164 statement. 164 statement is 6 page states. Her brother-in-law, my lord. Accused brother-in-law of the victim. At one so and so, I was sleeping in my house alone that day. My husband was in Guwahati as he works there. I have 2 jars. They reside in the same compound, but in a separate house. While I was sleeping, Sofiur Rahman came, switched off the light of my room. I woke up immediately, asked him why he had entered my room. Sofiur Rahman told me that he would take and marry me. I told him not to do so. Then Safi Rahman, so and so, my lord. Thereafter, I called my Tuja. So everything happened thereafter. Called my lord. They came. The court Safi, the public turned up. Safi house is 2 houses apart from.
That is exactly what Mr. Chaudhary, if I'm not if I've not understood him correctly, he's saying that if it is there, the fact that the boy was there, the accused was there, it's beyond doubt. He was there. But how he came there, whether there was a consensual thing or it was a rape. That's all. If I go by what Mr. Chaudhary is saying, then that if it is consensual, 376 with that figure may not come in.
Okay,
So at least for a bail, that was just a banter between he and me. Yes, Mr. Singh.
My lord. My case is very simple. I think my brother will start. If your lordship ask me, definitely I will start.
I have not started, your lordship. He is for the respondent.
My lord, what has happened in the present case?
Now, can you, Mr. Singh, what do you say on this? I understand a witness coming, deposing, adducing evidence along with documentary evidence, finished. Subsequently, a need arises for a re-examination. He is recalled. Now, while he is deposing on being recalled, can he produce a document which is never there?
No, my lord. Then I will have to correct my learned brother if he has so argued, my lord. Kindly come to the evidence part.
Was this document available on record
Yes,
at any point?
and that was a question was raised. Why photocopy? Because the original was never seized by the police. The photocopy was always there in the record. And he spoke about this document. And a cross-examination, a question was also asked. Kindly come to page 13, my lord.
Page 30.
13, 13. 13. 13, annexure 2. Before I read out, my lord, let me first inform this honorable court that the English translation is not as good as it ought to have been. So
You can
certain
go to the
words,
vernacular
He is
one.
a vernacular, my lord, better, I also agree, my lord.
but the
You can go to
handwriting
the
is also
vernacular.
defined. The vernacular starts at page 15.
15. Ezahar Kariya.
এজাহাৰকাৰী আৰু আসামিক চিনি পাওঁ 2002 চনৰ ঘটনা এজাহাৰকাৰী আসামীৰ ঘৰৰ ওচৰৰ মোৰ মটৰচাইকেল ব্যৱসায় আছিল সেই সময়ত গোচৰীয়া মোক লগ ধৰি এই কমিটি খুলিব বিচাৰে আৰু মোক সদস্য কৰিব বিচাৰে 20 জন কমিটিৰ ডাক দি দ্বিতীয় মাহৰ পৰা 5000 টকা উধাৰ দিব বুলি কয় গোটৰ সম্পাদিকা আসামী আছিল সেই দৰে ডাক চলি থাকে কমিটিৰ কামত খেলিমেলি দেখি মই স্টাম্প পেপাৰত সম্পাদিকাৰ পৰা টকা দিম বুলি লিখাই লওঁ this is the stamp paper my lord which is now being produced in original which was never seized by the police now kindly come to the cross examination মই জমা দিয়া এই কাগজখন ফটোকপি আছিল the very stamp paper that was always there in the case record but it was only a photocopy it's not that out of blue my lord this document we are speaking about
Further.
my lord
Read further.
examination first line মই জমা দিয়া এই কাগজখন ফটোকপি আছিল that is why this was not exhibited and he is PW4 my lord when this cross examination went ahead thereafter he goes and he looks after for this document ultimately he came across this document on 15th of May 2013 and immediately thereafter he moved an application the application was moved by the informant and she prayed before the court either she should be recalled or the PW4 may kindly be recalled so that the document can be brought officially on
Bakul
record.
Doctor is PW4.
PW4. And he was having the original, but he didn't remember where it was kept. And the police never bothered to seize this document. But it's not that, my lord, this document was not there on record. It was very much there.
Now, your lordship may kindly see their application, my lord, under section 311, F page 10. It was not seized by police. It was referred to in the examination. Your lordship may kindly see paragraph that the case is now fixed for recording statement under section 313 of the CRPC. The PW for Babul Dutta has adduced his evidence who was having an agreement after the notice anomalies of the running committee by the accused. In his evidence, he verbally referred to about the agreement. Your lordship may kindly see, and even he was cross-examined on the same by defense. Since the original was not really traceable by Sri Babul Dutta, was not even asked for and seized by the police. It remained with Sri Babul Dutta and did not realize importance of the same. After his cross-examination, this is important, was over, Sri Babul Dutta started looking for the document, and on Iman, he found the same kept in his old magazine, which was lost while transferring this shop from Iman. So that is the case, my lord, because it was never seized, it was produced before the court, my lord, police, my lord. It was only referred to in his oral examination. That is his own application, my lord. And your lordship, this regarding the, my lord, my lord.
Now, how do you say, Mr. Singh, that this was there, that at least a photocopy was there with the police from the word go?
Exactly.
It was also on record, my lord. In the lower court record, it was there. And that is why the question was raised by the defense also.
Where do I get it?
This is in the LCR, my lord. Since I am at Tejpur, my lord, my brother will definitely help the honorable court.
It's an agreement.
It's a declaration, better to say, my lord.
Huh?
It's an agreement. It has been written as Sukti Patra.
But it would be in the case diary only, maybe.
It is on record, my lord, in the
LCR.
LCR, my lord.
Not exhibited, my lord, how it can be on record.
No, it was never executed. That's fine. That is why this application was moved. But if the defense is saying that it was never brought on record, that is wrong, my lord. It was always there. The photocopy was always there.
Okay, find this out for me.
And he never, my lord, made an attempt, my lord, to exhibit this same in his evidence. Why he has not made any attempt, my lord?
That is why the application under section 311, my lord.
That document, at least a copy of that was there.
My lord, he was here referred to. He's produced this photocopy at the court, my lord,
Okay,
not
fine.
before the police.
Fine. The photocopy production is admitted to. Original was not produced. Now, would that be a bar? Because this is not a new introduction.
My lord, your lordship may kindly see that procedural part, that investigation part, CRPC, my lord. Your lordship may kindly see.
Yes.
Chapter 12, my lord, deals with this, my lord, the investigation process, the power of the police to investigate. Your lordship may kindly say section 170. 161 is the recording of, my lord, that witness. Section 170, your lordship may kindly see. I am referring to section 171. The case is to be sent to magistrate when evidence is sufficient. If upon an invasion under this chapter, it appears to the officer in charge of the police station that there is sufficient evidence or reasonable ground as aforesaid, such officers shall forward the accused under custody to a magistrate empowered to take cognizance of the offense upon a police report and try the accused or commit him for trial. Next, your lordship may kindly see section 173(5), subsection 5. Subsection 5. When such report is in respect of a case to which section 170 applies, the police officer shall forward to the magistrate along with his report all documents or relevant extracts thereof on which the prosecution proposes to rely other than those already sent to magistrate during investigation. The statements and 161. Now, if it is for any, my lord, further investigation required, that is a dear, my lord, that subsection 8. That was not done by the prosecution, my lord. They never prayed for. All the documents have to be submitted.
Now, Mr. Singh submits that this document, at least, was there on record.
But
is it on record in terms of 174(5),
yes,
173(5), or during your
exactly
deposition?
No, it was already there, my lord. Since what had happened, my lord, let me clarify. The original case was lodged before the CGM, North Lakhimpur. Thereafter, the
Complaint.
CGM forwarded complaint, but CGM forwarded, it was not treated as a complaint. The complaint petition itself was forwarded to the police concerned for registering.
That became the FIR.
So that was already filed there. It went along with the entire set of documents that we had submitted. So it is not the case that it was not there, my lord. Bunch of papers had been filed which contains passbook and other documents, my lord. In the middle of the document, your lordship will find this piece of paper, the stamp paper. The photocopy was always there. And my lord, looked into.
50 potro. Okay.
And one
So-
more thing, my lord.
This can be treated to be a part of the FIR if we hold it.
And it is not that we have taken the defense by any way surprise, my lord. The very contention is wrong. And even the defense put a question on this document. Now, if the defense says that we have been taken by surprise, it's totally wrong, my lord, against the record. And moreover, my lord, if section 311 is looked into, does it create any sort of embargo in even introduction of a document which is of essential character, my lord, for the adjudication of the dispute? It doesn't create any embargo.
Any decision?
Yes, my lord. I am relying on two decisions. The first decision on which I place my reliance, my lord, is 2013 Supreme Court, page 3081.
AIR.
AIR, my lord.
2013 Supreme Court.
Page 3081.
Para.
And I urge the Honorable Court to look into para 14, my lord, and para 23. Now, if your lordship look at para 23, your lordship will find certain propositions of law. So far, the application of section 311 has been laid down by the Honorable Supreme Court in the form of A to N. Now, if your lordship look at column number B, the exercise of widest discretionary power under section 311, CRPC should ensure that the judgment should not be rendered on incoherent, inconclusive, speculative presentation of facts, as thereby the ends of justice would be defeated. Now, my lord, if this document is removed, there will be inconclusive decision, my lord. C, if evidence of any witness appears to the court to be essential to the just decision of the case, it is the power of the court to summon and examine or recall and re-examine any such person. It continues, my lord, if your lordship again look at para N proposition, the power under section 311 CRPC must therefore be invoked by the court in
You are
order
reading
to
to?
meet the, my lord.
You are referring to?
I am referring to paragraph 23, the different proposition of law.
Which proposition are you now referring to?
N, my lord, N for Nagaland. The power under section 311 CRPC must therefore be invoked by the court only in order to meet the ends of justice for strong and valid reasons, and the same must be exercised with care, caution, and circumspection. The court should bear in mind that fair trial entails the interest of the accused, the victim, and the society, and therefore the grant of fair and proper opportunities to the persons concerned. Now, my lord, again, I'm saying that there is no sort of surprise to the defense. The defense was aware of this document. The defense even put a question on this document saying that since it's a photocopy and there was no other option but for the PW4 to admit that it was a photocopy. Now, when the PW4 wants to come back again in the witness box along with the original, the defense will have the opportunity to cross-examine. It's not that merely by tendering it will be admitted. They will have the opportunity to cross-examine on the original. Why the defense is so worried, my lord? Now, apart from this, my lord,
Okay, then next.
next AIR 2007, my lord, SC, page 3029. Para 11, 12, and 13. Para 11, my lord, the object underlying section 311 of the code is that there may not be failure of justice on account of mistake of either party in bringing the valuable evidence on record or leaving ambiguity in the statements of the witnesses examined from either side. Now, my lord, if this document is removed, a valuable piece of document is actually not on record in the form of its original. That is what we want to bring. The determinative factor is whether it is essential to the just decision of the case. This section is not limited only for the benefit of the accused, and it will not be an improper exercise of the powers of the court to summon a witness under this section merely because the evidence supports the case for the prosecution and not that of the accused. The section is a general section which applies to all proceedings, inquiries, and trials under the code and empowers magistrate to issue summons to any witness at any stage of such proceeding, trial, or inquiry. In section 311, the significant expression that occurs is at any stage of inquiry or trial or other proceeding under the code. Now, if you look at para 12, my lord, as indicated above, the section is wholly discretionary. The second part of it imposes upon the magistrate an obligation. It is that the court shall summon and examine all persons whose evidence appears to be essential to the just decision of the case. Now, may I pause for a moment, my lord, and may I take your lordship to section 311. There are two parts, my lord. Very interesting part, my lord. Kindly look at section 311, my lord. Any court may, the verb used is may at the first part. At any stage of any inquiry, trial, or other proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, semicolon. And the court shall. Now the verb is changed by law. Shall summon and examine or recall and re-examine any such person if his evidence appears to it to be essential to the just decision of the case. Now, my lord, if this is the one of the important document already on record, and if this honorable court or the magistrate found this to be essential, my lord, and since there is an opportunity to the defense to cross-examine the witness, my lord, where is the legal harm or legal embargo which my learned brother is arguing?
Basically, you are trying to project that the court must be open to receive relevant materials.
Relevant material, if it is necessary for just decision. And to add my argument, my lord, this document is nothing new. It was already there, and the evidence to some extent was laid in the chief. Thereafter, there was cross-examination of one sentence. Since it was a photocopy, my lord, it was not exhibited. Now, it is the same document which we want to introduce by bringing the original.
My lord, regarding my learned friend's my lord argument regarding recall, re-examine, witness, there is no dispute at all. It can be done. But after the examination, everything is done. My lord, evidence is closed, my lord. Whether this document can be produced or not, that is the question of that. And there is.
Or if I can put it in a different manner, Mr. Sharma, whether the prosecution now can be permitted to fill up the lacuna.
Exactly, my lord.
That's
Exactly.
what you're trying to.
Exactly, your sir. Exactly. They are trying to fill up the lacuna because your lordship may kindly see there his evidence was recorded on 5th of October 2012, and he filed his application 27/5/2013. 2000, my lord, after the gap of almost more than 6 months. Now, this at his argument stage, your lordship order reflects that it at the argument stage. Whether prosecution can be, but this decision is, my lord, very much clear. This decision says our High Court that it can be done. Everything can be done. That's
Okay.
But only the documents part, my lord. Whether they can be allowed to, my lord, produce these documents, exhibit the documents. His evidence is close, right? And in my process, and he has admitted in my cross-examination, when it was referred that original was given or not to the police, then he realized that yes, it may be. Because that fill up the lacuna. Because in cross-examination, I put the question whether original was given to the police or not. He said no. He said that no.
My lord, I just only want to add that this honorable court has to decide the necessity of the document. If this honorable court finds it to be essential, then the stage doesn't create any sort of embargo or bar, my lord, in its introduction.
No, I've got it.
That is why the verb shall has been used in the second part of section 311.
Shall may both have to be read in the context the power is being used.
My lord.
If the court wants that this man has to be recalled, then that shall would mean that it has the power to recall that.
Recall, my lord. Now, my lord, second issue, my lord, I would like to urge is that the defense did not raise any written objection before the learned trial court so far when this application was moved. And in our application, there is an explanation as to why this document could not be brought earlier. He shifted his shop from KB Road to other area, my lord. That is not in dispute, my lord. And there he found this document.
He has said that.
My lord.
He has said that in his application. To the
My
list.
lord. That is not a challenge.
Let me just go through the LCR also once. And then you're coming to Gauti these days, Mr. Singh, any day?
My lord, my father is in ICU, so I have to wait
Hope
here.
he is keeping, is improving?
Not, my lord, that is the unfortunate
Oh my
part.
good God. How long has he been there?
For the last 5 days, my lord.
Anything attack
My
or
lord,
something?
there is no improvement. That is the main worry, my lord.
You can't even
He
shift
is
him now.
stable, but from last 2 days back, he has not been able to recognize any one of us. Only he can recognize my voice. So that is why I.
No, you should not leave. You should not be there. You should be there.
Brother, it's a effect of old age or
Something, some stroke or something.
Old age or
He is of the age of 88, my lord. He had a bypass surgery in 2012, and last year he had a brain stroke. But this time, my lord, he had fallen outside the bathroom, not inside the bathroom, and had got head injury. After that, head injury, but it appeared to be superficial head injury. But when we took him, some medicine had to be removed. And the moment the medicines were removed, even for one single day, that created havoc, my lord. Now the doctor is finding difficult to keep him in condition which
you can't even, it's not, maybe he's not in a position even to be shifted now, even to Gauti.
No, my lord, because of the old age, the operation, is not.
We all pray. Let him, hope he gets better. He gets better.
In my father's case also same thing. In 93, he fell down, and thereafter, my lord, he could not, my lord, get up. After 1 year, my lord, we lost.
What I do is, Mr. Singh, subject to what you are in a position to do that, I'll have this matter listed again on Wednesday. I'll just go through. If there is any query required, I'll ask for a clarification or I'll pass on.
Your lordship, on 10th.
11.
11.
No, 10th.
You need not come. Huh? On 11th, I said. Any problem? 11th, 12th also. No problem.
On 11th,
Let it be on 12th. Thursday.
Your
Mr.
lordship,
Singh, if you're having any problem, I'll adjourn the matter. Don't worry about it. Just inform me.
your lord,
Highly organized.
can it be on 10th, your lordship?
Why?
Yes, sir, 10th I have some point.
No, why? 12th, any problem?
No, I will not be here, your lordship.
12th.
From 10th, my father's 1 year.
Okay.
9th, 10th, I will be available.
10th I have some problem here also.
9th,
16th.
6th. Allah.
এটা মুখ দিয়ে দিব রে হার্ড ইন পার্ট
Obliged.
Yes, Mr. Rashid.
Sorry, Miller, in first morning I couldn't come, Miller, in another code. Anyway. Now here kindly similar to the previous bill, Miller. Kindly similar annexer, Miller, one. That is the Azar, Miller.
We are not very satisfied with the materials against you. There are incriminating materials.
But only one thing, Miller, from the Azar itself, Miller, there is no.
We don't think this is a case for, this is a case for,
302.
yes, Mr.
Yes, my lord, suicidal hanging is there, but there are, my lord,
Injuries, and you were the only person. I have given bail to your family members today. But you are the only person in the house with the victim.
I am the husband, but direct my name.
No. You are the person in the house. Your family members had gone out. At that point of time, explain the injury, how she sustained that injury.
But I was not there. I was not at home at the time.
Where?
I was on the relevant point of time. I was on a Lord for my labor work. I also mentioned my petition, Lord. I was not at home. And Azar itself says the in-laws, Lord. In-laws were torturing and beating her in connection with their
In-laws would come all. And on multiple occasions, the past so-and-so, with the accused number one at the other person.
And this time, Lord, mine below, not directly mine, below a making person. Who is that person, Lord? So, Lord, my prayer will have similar treatment may will give it, Lord. Other members are there, though I am husband, Lord, at the relevant point of time, I was Unasal, Lord, for my labor work. I have mentioned in petition, Lord.
Something, my lord, on that night, my lord, is there because, my lord, the blunt force.
Because the material that has come on record in the case diary is that these other family members had gone for some function somewhere.
Yes, some function is there, Lord.
They came back late and you were in the house. There is material to show that Mr. Parasar, that he was in the house.
My instruction is he was Unasal.
My lord, others have said that we are not there, and he is, my lord, under that day, he has fever. My lord, he is suffering from fever, this petitioner. So he is in the house, others.
No, I'm not. He says he was not in the house, alibi, that he was in Arunachal.
My lord. And Azar may.
Where is your statement to that effect in the appeal here?
Yes, I was in Unasal for labor work. Paragraph, Lord. 6, Lord. Page 3, paragraph
Regarding
6.
that,
That a month or so back, the petitioner who is a mason by profession got an opportunity to work under a contractor in Arunachal Pradesh at the village Tapasya, so district Itanagar. As he was not making good money at home, he decided to go there to have a better income. That is Milo. And also, Milord, the Azar informant itself
but,
says that, Milord.
one line that I am reading, my lord, statement of the father-in-law, the deceased, my lord. My lord, he stated that on that night, one 7-year-old.
You read the vernacular,
Yes. যোৱা 10 তাৰিখে ৰাতিপুৱা 6টামান বজাত উঠি মোৰ ৱাইফ যেতিয়া শুই উঠে তেতিয়া তাই মোৰ নাতি ছোৱালী 7 বছৰ বয়স আৰু বিলকিছ পাৰভিনৰ ৰুমত কান্দি থকা শুনে মোৰ নাতিজনী বিলকিছৰ লগত শুইছিল লগতে বিলকিছ পাৰভিনৰ 3 বছৰীয়া বিলকিছ পাৰভিনৰ এটা ভিক্টিম মানে বিলকিছ পাৰভিনৰ 3 বছৰীয়া ল'ৰাটো সৰু ছোৱালীজনীও কান্দি আছিল মোৰ ঘৈণীয়ে যেতিয়া দৰ্জা খুলিব দিছিল তেতিয়া নাতিজনীয়ে দৰ্জা খুলিছিলে আৰু তাই বহুত ভয় খাইছিল দরজা খুলতে মোর ওয়াইফে সেক্রেটারি নেচাই বিলকিছ পাৰভিনে চিপ লৈ ওলমি থকা দেখা পায় ঘৰৰ চবকে মাতি উঠাইছিল so
He was not there.
in the room the 7 years old girl matlab sister-in-law's matlab daughter and the daughter of the deceased 3 years and 7 years but their 7 years old girl her statement is I have not found
That is.
And accused number 2 was
Okay, he'll appear before the police. That's all. He'll appear. Otherwise, you will not get him also.
And the accused number 2, who will not,
But
no, my brother similar treatment, maybe others is similar treatment, my brother. And this is,
or you want some more further?
matlab hanging is suicidal that is
That
also
is
police case,
suicidal. But the injury face.
face injury only because of the face injury. Hanging is because no ligation is not continuous.
No.
That is there. Only and other family members, well, her family members that all are
Involved.
that is there. But as for the statement of the in-laws, there's sometimes husband and wife is quite often in
That is not the one. But
yes, sir.
if he says that he was not there,
They correctly,
why don't you go through it nicely? Only on that plea. Whether he says that from 1-3, he is not there in. And the occasion on 10-3.
and the informant 2, he is the, sorry, accused number 2, he made a phone call to the informant. He came, but nowhere mentioned that I was there. Even the informant also not mentioned in the Azhar itself. That is not submission of lordship.
Mr. Parasa, you
My
go through it nicely. We'll take it up again tomorrow.
my lord, my lord,
Tomorrow we'll take it up.
my lord.
You go through it.
No.
I only want a
Only
clarification
that
whether he was there,
present.
his
My
plea. If he is not there, then how can he be? There might be some disputes,
yes, yes.
but this is not the reason.
Dispute was there only for money. I was a poor man, I had no sufficient money, so I need to earn money, more money, that is the main thing.
Heard the learning council for the parties as prayed for, list this matter again tomorrow. Slip video. I'll do video.
Tomorrow, my lord.
You just go.
My lord, today itself I will go.
Mr. Rashid, we'll have it tomorrow.
My lord, first.
Pagul?
My lords.